Hell no. Oh, it's court trial. Tell us someplace in prison, girl. Can't throw that. But, Dustin was mine, for years.
Okay.
That female wrong. That's not how money's broke.
On Nelson Plate. She already think, oh, I gotta go get Christine car.
Well, it's here on my list. I thought you needed two, I thought you needed Nelson and Warner.
Let me here. There.
Started here. Driver.
Okay. Thank you. These things, right? Have you filled out the public defender? What's your name?
Wait, Nelson?
There's your stuff, and if you didn't get a copy, and you can say. Driver, come on in here, and John Nelson has the stuff, you don't have to let it. You guys sit down. That. And we're happy. We're trying to get there. Great, amazing, yeah, it is. They declared, Berry County. Yeah, almost. You have to let her run it. Yeah, we just made a flash a couple times yesterday. We were okay. After the year. The migraine long. But. It's Saturday. It's Saturday. That's right. Yeah. But we got plenty.
Thanks so much. Very good. Okay. You just get her in jail. Nah, they promise. And you got a couple weeks.
You walk it. In there, come see.
Thanks is the first.
Thanks.
First. Is there any more chairs?
No.
Let me get you one. Oh, wait. Nelson was all.
John Nelson, there's your paperwork in case you didn't get a copy. They want you to have a copy. You can't say you didn't.
Community for two. Yeah, that's what this is about. I'm gonna get fixed. Honest, like, you get values.
Oh, sure. Good copy.
Yeah, but. I was supposed to start at 8.
Yep.
Okay. What are these idiots?
Good morning.
Morning.
Yes. Yeah.
Not just outside of two points, one.
But
I woke my computer up. Oh, here's the waiver, speed trial up here from yesterday afternoon. I know that's it.
We should have found these, and we would ask to address them all.
So.
Bless you.
Oh, man.
That's correct. Yeah. What about the
Who do we want to do first, Andrea?
Clayton Nelson.
Nelson, okay.
There's two Nelsons, so Clayton.
Clayton, okay, yeah, there's John and Clayton. So Clayton Nelson.
You're on record.
We are on record in the Meigs County Common Pleas Court in State versus Clayton Nelson, 25 CR 106. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am,
State your name.
Clayton Nelson.
Okay, we're gonna have your address sent to us by the jail, because we're live now, and I don't like giving out everybody's address on live, so. You're not, you don't have an attorney because you're incarcerated at this point. We'll talk about getting you one in a moment. We do have the state's attorney, she's gonna identify herself.
Yes, Your Honor, Abigail Gilkey, Meigs County Assistant Prosecuting Attorney, along with James Stanley, Meigs County Prosecuting Attorney, Harold Dallas.
All right, a motion to revoke community control has been filed against you. I trust you received a copy of it.
Yes,
I'm going to enter a denial on your behalf until you can have an attorney to assist you through the process. If you cannot afford one, one can be appointed. Do you want me to appoint one, or you need, or are you going to hire your own?
that's fine. You can appoint one.
Okay, we will appoint
Denise Bunt.
attorney Denise Bunce.
How
And
about, how about Brett?
you don't, we appoint people for different cases on a rotating basis, and for particular types of cases they're willing to. So you're not in a position really to negotiate. Denise is appointed. Next, we're going to talk about bond. What's the state's position on bond?
Yes, Your Honor, the state would ask the bond be set at $25,000 with 10% permitted. And just as the court is aware, there is a bond out of the Meigs County Court for him, as well as I believe an APA either holder, or they have a hearing going on, the state's still asking for the 25,000%.
Okay, so, but you still just want the basic PV 25,000?
Yes,
Is there a victim in his case?
yes.
And was the victim notified?
Shelley attempted to notify the victims, but the voicemail wasn't set up.
Okay. All right, the state is recommending what they typically do in motions to revoke community control, which is $25,000 bond with 10% cash permitted. You may make a statement about bond if you want to. You don't have to. Just make sure you don't make any statement about the underlying allegations, because anything you say could be used against you. Do you want to make any statement about bond?
Yeah, I asked that question. Since I'm on parole and this has all been taken care of now, and the other two is being indicted, can I go ahead and have my parole officer send me up with a rein and get that started? Because I'm on violation with that too.
On parole?
Yeah,
Yeah, well, if they need to take you, we're not gonna stop them, but that would have to be arranged. I'm still gonna give you a bond of some sort.
Yeah.
So that's the APA, your parole officer, which is that D.
yes,
Okay, whatever she does is independent of what we do, except to the extent that you're on PRC, which means you could have an enhanced sentence potentially on this because of the PRC status you're in. But yeah, she's free to do whatever she needs to do, but we're going to set a bond in this case. Do you have a statement about that bond?
no ma'am, thank you.
Okay, we're going to set it at 25,000 with 10% cash permitted, which would be, of course, $2,500. In addition, if you're able to make that bond, you're going to be on the Repath GPS monitoring system, which is an additional $250 per month, the first month payable upfront. Other conditions of bond are basically your conditions that you already have on community control. You can't use drugs, alcohol, or other mind-altering substances. You'll be randomly tested for those things. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms, and you can't get any other trouble. No contact with law enforcement resulting in charges or arrest. And was there a post-conviction no contact order?
No,
Who's the victim?
it's his grandparents.
Grandparents. So are they asking for, you don't think they're asking for no contact? Grandparents of Mr. Nelson do or don't want no contact? Okay, so the victims, which are, their names are? That's all right. So no contact with the victims, which I guess are your grandparents, but they are specifically? Deborah?
And I don't know, grandpa's name, he wasn't victim in this case, but he is the victim in the new case.
Okay, you don't know his name? Oh, and what's their last name?
Carsey.
Carsey?
Yes.
Okay, no contact with grandma and grandpa Carsey, directly or indirectly, is another condition of your bond, and we'll schedule hearings for.
We will set a probable cause and final PV hearing for August the 18th at 10.
August 18th at 10. And your attorney's information, contact information will be included in the entry that you'll receive today there at the jail. Do you have any questions?
Ma'am.
All right, then we'll switch. Who do you want to do next? The other Mr. Nelson?
Sure.
And let's do
John
John Nelson.
We're on record.
We are on record in the Meigs County Common Pleas Court, State versus John Nelson, case number 24CR099. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, Mr. Nelson. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name,
John Nelson.
and we'll get your up-to-date address. Do they have it there at the jail? Your current address?
Yeah, it's 39212.
We'll get all that information so that it won't be over the air. You don't have an attorney with you, obviously, because you're in jail, but we'll talk about getting you one in a moment. The state's attorney is present. She's going to identify herself.
Yes, Your Honor, Abigail Gilkey, Meigs County Assistant Prosecuting Attorney, along with James Stanley, Meigs County Prosecuting Attorney here on behalf of the state.
And there would be a victim or victims in this case. It's a non-support case.
Yes, Your Honor.
Were they notified?
Yes, Your
Okay, so you were also faced with a motion to revoke community control. So I trust you received a copy of that?
Just now.
Okay, that's fine. It's not like an indictment. We're gonna go ahead and arraign you. So you have seen it though, right?
Yeah.
Okay, so I'm gonna enter a denial on your behalf at this time. You need an attorney to assist you through the process. If you cannot afford one can be appointed. Are you gonna be able to hire your own, or you need one appointed?
Take one.
And we'll appoint
Denise Bunt.
Denise Bunce, and her contact information will be on the paperwork. Next, we'll talk about bond. What's the state's position on bond?
State would ask the bond be set at $25,000 with 10% committed.
As with the other Mr. Nelson, the state is asking for what they typically ask, which is $25,000 bond on a motion to revoke community control. You may make a statement about bond, but I caution you only to talk about the issue of bond, but not about any of the underlying allegations. Do you have any statement on bond?
No.
Okay, I'm going to set it at 25,000, 10% permitted, which of course would be $2,500 plus the GPS repath monitoring if you're able to make the bond. And your conditions are basically what you already have as conditions, which are among your conditions. You have a lot of other ones too, but you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do anything with firearms. Can't get any other trouble. No contact with law enforcement resulting in charges or arrests. If that would happen, you must report it to the court immediately. Is there any request for no contact in this one? Okay, so child support, the bigger stuff. Okay, with that then, we'll schedule hearings for
We'll set a probable cause and final PV for August the 19th at 1.
August 19th at 1. And those dates will be on the piece of paper that you'll receive later today there at the court or at the jail after the court gets it signed. Do you have any questions?
No.
All right, then. Who do we have next? Mr. Schreiber?
This is a brand.
Yeah, thank you. We're on record in the Meigs County Common Pleas Court, State versus Schreiber, case number 26CR100. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, sir. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. If you would state your name, please.
My name's Joshua Schreiber.
Right, and do you have a physical address and a mailing address that you've provided to the jail?
I believe so.
Okay, we need to make sure that we get that, and we'll endeavor to get that from the jail directly. You don't have an attorney. We'll talk about getting you one in a moment. We do have the state's attorney, and that would be
Yes, Your Honor, Abigail Gilkey, Meigs County Assistant Prosecuting Attorney, along with James Stanley, Meigs County Prosecuting Attorney, here on behalf of the state.
all right, and there clearly would be a victim in this case. Is the victim notified?
Yes, sir.
Is the victim present?
She should be on Zoom.
Okay, that's fine. So we can go ahead and proceed as far as you're concerned. Okay, you were indicted, Mr. Schreiber, by the Meigs County Common Pleas Court grand jury on August 5th, 2026. It's a one-count indictment for violating a protection order. So I trust you received a copy of the indictment?
I have one, yes.
Okay, and did you receive the written copy of it more than 24 hours ago?
Yes.
Okay, you have the right to have the indictment read to you in its entirety, word for word, and I'm happy to read it to you. Or if you feel comfortable reading it because you know you're good at reading written English, you can waive the reading. Do you want me to read it or you want to waive the reading?
I have read it.
Okay, so you want to waive the reading, not have me read it because you feel comfortable, you've already read it?
Yeah, I'm okay with waiving because I've
Okay.
read.
Okay, then I will tell you, since you don't have an attorney yet, it's a felony of the 5th degree, which carries potential penalties of 6, 7, 8, 9, 10, 11, up to 12 months in prison, a fine of up to $2,500 or both. Do you understand the potential penalties? Do you understand the potential penalties? Can you not hear me, Mr. Schreiber?
Yes, ma'am, I can hear you.
So do you want me to explain that this carries potential prison sentence because you have a previous conviction in the misdemeanor court system? And so the allegations here is that because you already have a prior conviction for violating a protection order, you're looking at potential prison. And that prison could be anywhere from 6 months, 7, 8, 9, 10, 11, or 12 months, up to 12 months in prison. Or any of those months in between could be the actual sentence, and up to $2,500. Do you understand the potential sentence?
I hear you. I don't understand the charges, so I can't say that I understand the penalty because I don't understand the charges against me.
Okay, well, the charge is for violating a protection order. So say the allegation is that you did recklessly violate the terms of a protection order issued or consent agreement approved pursuant to section 2919.26 or 3113.31 of the Ohio Revised Code. So it's basically saying there's a protection order in place. You're the person that's supposed to have no contact with someone else. And the allegation is that you had that contact, which constitutes a crime. So that's all it is an allegation at this point. What happens is we get you an attorney and he or she will then be able to get all the information the prosecutor has and then be able to better explain to you why they brought the charges, what kind of factual evidence they think they can prove. So you're not expected to fully understand other than the kind of the nature of the charge, the potential penalties. So does that help you?
I hear you. I wouldn't make this mistake again.
Okay, you
And
don't want to make any statement. Don't make any statement because anything you say could be used against you. I'm going to get you an attorney in a moment. So you don't want to make any statement about the underlying charges because anything you say could be used against you. You understand that?
yes,
Okay, so next we're going to talk about getting you an attorney if you need an attorney appointed, or you're going to tell me who you're going to hire if you hire your own. Do you need one appointed or are you going to hire?
I need one appointed, please.
Okay, and we will appoint Attorney Denise Bunce, and we will next talk about bond. What's the state's position on bond?
Yes, Your Honor, the state would recommend an OR bond in this matter, and ask that the defendant have no contact with the victims that were good. State's asking for an OR bond because he is currently has a commitment until October 23rd to Meigs County.
Okay, so the state is asking that I give you an OR bond, and I assume you have no objection to that? The personal recognizance, your signature would guarantee your appearance. Do you understand that?
Could you say that again, ma'am? I'm sorry.
Sure. So I've asked the prosecutor what they're requesting for bond. And in your case, they're asking that you be allowed to be released when you're eligible to be released out of your other case on an OR bond or personal recognizance bond, which is a signature guaranteeing you will appear at each hearing.
Yeah, I've always appeared in my hearings and I would continue to do so, yes.
Okay. So an OR bond is significant because this charge is a felony. And if you would fail to appear at any scheduled hearing after you sign the bond, then you could be charged with an additional serious felony. Do you understand that?
Yeah, I wouldn't do that.
Okay. And well, of course, during your period of incarceration, it'll be the responsibility of the sheriff to get you here. So this would really, you'd only get in trouble if you were out of jail and didn't show up. Also, since you already I don't know if you are, but you do have conditions of a bond that would be that you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified, which I assume you are already because of the underlying allegation and the previous conviction, but it would be that you cannot use, possess, acquire, or have any contact or be in possession of any firearms or attempt to do that. And you can't get any other trouble, no contact with law enforcement resulting in charges and arrest. And of course, you already have a protection order, but additionally, I'm going to put the condition of bond, there's no contact with Deborah Good, directly or indirectly. You understand the conditions of bond?
Yes, ma'am.
Okay, and we'll schedule hearings for,
We will set an initial pretrial for September the 2nd at 10:15.
Yeah.
Final pretrial and motions hearing for September the 30th at 10. And then a jury trial date of October 27th at 8.
those dates are all going to be on the arraignment entry that you'll receive today. They're on page 2, so make sure you read the whole document. It'll also talk about your bond, your attorney, and her contact information. You also have an order that you have to be fingerprinted and photographed for this indictment. It may have already happened, but we'll still put that order on the record. Do you have any questions?
No, ma'am, not at this time.
Okay, you probably have a lot of questions, but it'd be best if you ask some of those of your attorney. You understand?
Yes.
Okay, thank you. Then do we have a female up there?
Yes, Miss Browning.
Okay, I'll ready to switch to her.
All right, Miss Browning, go on in. You got everywhere.
Mrs. Browning?
We are on record in the Meigs County Common Pleas Court in State versus Browning, 25 CR 045. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Jessica Browning.
Okay, say that again. It was kind of muffled.
Jessica Browning.
Jessica Browning. And did you give an accurate address, physical and mailing address to the folks at the jail?
They got 9 Fisher Street.
Okay, so that's you can get mail there and you live there.
Yes, yes.
Okay, all right. And you've been well. First, we're going to tell you we're going to talk and get you an attorney in a little bit, but we're going to identify the prosecutors that are here.
Yes, Your Honor, Abigail Gilkey, Meigs County Assistant Prosecuting Attorney, along with James Stanley, Meigs County Prosecuting Attorney here on behalf of the state.
Okay, and this looks like there would not be an individual victim. So a motion to revoke community control was filed against you. I trust you received a copy of it.
Yes, I got it.
Okay, I'm going to enter a denial on your behalf at this time. You need to have an attorney to assist you through the process. If you cannot afford one, one can be appointed. Do you need one appointed?
I guess I was just gonna plead guilty to it.
No, you don't want to make any statement until you talk to your attorney because you're looking at prison. So you certainly have the absolute right to have an attorney to assist you through this process. And if you want to hire your own or feel like you're in a position to do that, that's fine. But if not, if you can't afford one, we'll appoint you one. So do you want one appointed or are you going to hire your own?
Court appointed one.
Okay, and that would be
Denise
Bunce. Her contact information will be on the paperwork. What's the state's position on bond?
State asked the bond be set at $25,000 with 10%.
Okay, the state is asking that the bond be $25,000 with 10% cash permitted, which is typically what is requested on these types of cases. Do you want to make any statement about bond? Again, don't make any statement about the underlying allegations, but just about the bond, which is about making sure you appear.
No, I mean, that's fine, but I was wanting to talk to Brittany so she could see if I could see if she could help me go to rehab or help me get help, you know what I mean?
Okay, so you're interested in, instead of sitting in jail waiting, potentially going to rehab?
Yes, yeah.
Okay, well, that's good. We're gonna make sure your attorney knows that as soon as she's over here for her other hearings, and she will work with Brittany and try to find, have you ever had inpatient care before?
No.
Okay, so there's a number of facilities that the court commonly uses that communicates with the court and are involved in our drug court. So they're both some faith-based, some non-faith-based, and you.
See if I could go to Field of Hope.
What did you say about Field of Hope?
I was just gonna see if I could go there, if they,
Okay.
if I could, because I've been checking up on it, reading up on it, and I was gonna see if I could go there. If they could get me in there.
Okay, well, we'll tell your attorney that, and oftentimes they do help get people in quickly. So what I'm gonna do on your bond, and I'm gonna set it at 25,000 for now. But if you're accepted into a inpatient treatment program, it will be modified or changed to an OR bond, which means you'll have to sign to get out. And you would go directly from being an inmate of the Meigs County prosecutor to going to the treatment facility, being picked up by the treatment facility. So you're not like going home and in between, and that you would have to remain at that facility and be in full compliance with their program until further order of the court. So that would be getting you into a program, getting you oriented and having your hearing on down the road after you've been in your program for a while. So right now it's 25,000, but I'm happy to change it once you have a bed and arrangements to be picked up. And the conditions of bond continue to be some of the same conditions you have for community control, which is you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. Your firearms disqualified. You cannot own, possess, acquire, use, or attempt to do anything with firearms. And you can't get any other trouble, no contact with law enforcement resulting in charges or an arrest. You understand the bond conditions?
Yes.
And we'll schedule hearings for,
We will set a probable cause and final PD. Actually, if she's gonna go to treatment, I'm gonna set
Yeah.
it out a little bit.
and hopefully, yeah.
Yeah.
She wants to do that. Certainly going to encourage it.
Let's use September the 9th at 1 instead of the other date.
Okay. So your hearings will be September 9th at 1. Brittany is probably actually listening to this today. If not, we'll send her a message. And when Ms. Spence gets here, we'll also mention it to her that you're wanting to get into treatment as quickly as possible. Anything else from the state?
No, Your Honor, thank you.
You have any other questions, Ms. Browning?
No.
Okay, well, I appreciate that you want to get help and we want to help you get help. So we'll work towards having that happen as quickly as possible.
Right, thank you.
Thank you. Anybody else at regional?
That's all you have today, ma'am.
All right, thanks so much. See ya. When do all the rain, huh?
9.
9, but don't we have a hearing with Denise before that, right? Did someone send Brittany a message about this one?
I thought she wasn't.
She may be listening. I don't know. But of course, if she got somebody in there, even if she was listening, she might not be.
Oh, she is listening. She texted.
She texted, okay, good.
Um. So I have a question.
Yes,
So I've never had to do this whenever I get these from the jail. Is the jail, how are we gonna get those sheets from them? Do they even have them?
I had asked Tom to take them up there, but I don't know if he got that organized yet.
Okay.
We might have to ask them when we're scheduling these to get those to us, or have Brandy.
And Brandy's one that's scheduled.
I was gonna say, I would probably have Brandy make sure she's got a good physical and mailing address from each one, gives it to us ahead of time. Cause I want to make sure we have it in the file, but I don't want to televise their addresses. Of course, she just told hers, but
Yeah. She can compare people.
yeah, and that's fine. Yeah. That's fine. So is Mr. Wright in jail?
No, you bought it out.
Okay, so is he here?
Questions?
I know he's got 3 minutes. Like I said, it's got 3 minutes. No one is down the long hallway either.
No.
We must have someone bringing someone from, Field of Hope, because I have a message that Field of Hope is running behind due to the flooding. They have Jessica Canterbury, just FYI. I probably gonna send a message to the stunts.
She texted me.
Oh.
About this hearing, so she has an offer and she's aware.
Okay, but did she say she was running behind? So we're ready for your 9:30 hearing. We're also looking for the client, so. I will step out and try to watch the monitors to see when she arrives.
Here. Still moving. Right, and then, yeah, 584.
Situations.
You will.
So, before go, this one I found, this is just, for some,
Oh, yeah.
it's just, violence, problem. So he's already lost harmless one.
Or maybe I don't know, like, I don't really know, I've never had any of it, but he's like, really.
You know. In all. Those subject, so it's showing. So what's about both the 7 to the 9?
Met your court out last week and we sat around for 2 hours waiting for it to come on. Like, I'm gonna just see that I have to dinner and then it's gonna come back on.
Shows all about using a 5 6 cases. Versus that,
They say when we about 6 days at a time.
I gotta find out who the other one.
Also, we have. Like, how all the one pieces.
I don't think of those things there.
Also,
They're the same. I can do it. I should do this stuff. Like it's some. It's like, so you should, I really like these. Hopefully. Thanks. Sure, it's like nice.
Doing all right, how about you?
I'm just.
Are you? Okay. I know.
Is not in jail.
Okay, I wondered, I didn't know
Just
that.
called him and he.
For
he
overslept?
Forgot his hearing was 8:30. So
Okay,
then he said he was on his way,
okay,
and 3 minutes later he called the clerk's office and said he was having car trouble, so.
okay,
Who knows if he'll be here or not.
okay. Well, we'll have to vote on, I guess. That sucks, okay. Why do we have Mr. Blankenship? Is he in jail? I wonder, hey, look. You guys probably don't know right off hand either, I expect. Let's see. Obviously, they don't call me and say, hey, how's it going? Once in a while, I have people that are concerned and they will call me and I'm glad about that. Sometimes.
People in jail.
No, people, well, yeah, people in jail actually sometimes call me more than people that are not in jail.
That's not like so.
They're anxious. Yes, yes, Mr. Blankenship. Okay.
So it's supposed to be in person at 9 though.
Mhm.
And,
Well, they're running behind on the jail stuff, is what I was told downstairs. That they had a lockdown at the regional jail and it took longer than to get them out. So somebody did something they weren't supposed to there,
just.
allegedly. These names look too soft. Our government handbook is gonna be arraigned today too, on another charge. At 9.
Yes.
I hope that he returns sometime. I even went to see his mom.
Oh, yeah.
I went to school with his mom, and I went to see his mom and asked her if she could get a hold of him. He did go to treatment at one time. Because when I talked to her, she said he was in treatment. She was trying to be home. This new system we have is gonna make it hard for me to get his phone numbers. Unless they have it on their AOI, but if they haven't filled one out, then I can't get it.
They would have them write them on papers.
Right, but where does that paper
I
go?
don't know.
That's the thing. I don't have access to that. I guess maybe I should ask the judge to get me copies of those. So maybe I need to start doing is say, hey, all my clients can have a copy of these and all the next ones. I mean, I try and write stuff down about here, but sometimes I'm not sure if it was hearing. So. All right, let's see here. What's your name, sir? Are you Shane? Jamie, okay, thank you. Who are you guys? Okay. Thank you. Yeah, I was gonna say, unfortunately, you're not one for me.
We're waiting on you.
I was like, oh, somebody early, right? Not for me. Sometimes I get that. Yeah, that's right. People are nice to me sometimes. I need that. I don't deserve it, but I need that once in a while for somebody to be nice to. Why? Years since. How come small one? Yeah. No, it doesn't. It says, and there's a GoFundMe for his widow and child. I don't think that was in GP. That's all. Anything more for Mr. Wright? Maybe?
I've got an article about that actually. This is something that was just.
Where they have been married long enough or something.
So this appearance. So that's why there's a good one.
Uh-huh. Well, that stinks. Hey, Cassidy,
Niece,
I got a question for you.
I may have an answer for you,
Yay. Okay.
depending on what it is.
Well, I might have to ask the judge too, I don't know.
Okay.
I was just thinking that, of course, if we have AOIs, and when I'm here, I try to make sure people fill them out. And that way I get like phone numbers and things of that sort, but I was just thinking that maybe is there some way we could get access to those, forms you guys have everybody fill out?
That's a judge question.
Okay.
Definitely on, yes.
I wasn't sure if you would know that one or not, so didn't know if anybody else would ask, but started thinking about it. Cause sometimes.
You guys have the arrangements?
Yes.
Stop in. You guys wanna hire your own attorney or what? We got, I mean, so you hired your own? Yes. Okay, so you're on one of these. Then make copies real quick. Okay. If you would, this is your information the court needs, that everybody's lives, so it's ask you to open the report, we gotta break it down.
Our house was flooded. I mean, this Malcolm's old mom, Long Corners, widow, comes back home and finds that our house had gotten flooded.
Artist one, or one.
And that's his bag, I don't know, this level. State plan that he didn't sign. Yes, and I have had a few times that I prepared wills for people and then we got them for change and sign. Crazy. Yes.
The year, the state.
Basically, my kids, my girls, went to Myrtle Beach yesterday. Borrowed my car, so I'm driving their old car. It's hard to climb in and out of their car, I'm telling you, it's really low. My sister and I were talking about, I guess cars were like that maybe when I was young, of course, when you don't know this, they're original, people buy it. It looks good. And people didn't really have SUVs back in our day. I mean, some would have wagons with them. Like a little big station wagon, you know, so. My mom and dad had a couple of station wagons. And my mom moved up in the world and got a Cadillac. And she had a Cadillac, and once she got her first one back in the late seventies, so she has one in Bill, now she has it. No, it's her thing. Yes, well, she wanted to live where she lived. That was her version of that. I was gonna say, the people that know my mom or knew my mom. That was her who she was.
For vehicle, or
Her vehicle, and just her. She was, she loved to wear red. She loved to wear, her three colors were red, black, and white. So she wore a lot of bright colors. I guess I do too. Not quite as much as my mom, but I'm a little dark, so maybe the person that's probably most like her is my sister that works with me. Yeah, she's a lot like her. She was well known, mom was well known for her temper too. Yeah, I don't know, I mean, I feel like I wouldn't do good if I should have mad all the time. Well, that's just who I am. Some people in my same job are very angry and see people okay, you know? Don't you know certain people, I would say names, it seems like they're angry a lot, maybe they don't answer. Maybe it's a performance, I'm sure, but
yeah.
that wouldn't be bothersome, that perform or whatever.
Next thing. Most of the people that we deal with. Very usually. Generally good money. Or decent money. Sometimes it works.
Yeah, well, maybe jerks, maybe, I don't wanna say that.
Yeah. Or I find it as well.
When I think about these teams, because now my kid and family are like, John, you're going, go. And I'm like, oh. I'd like to opt out, please.
Yeah, I can hear it on one side.
Oh, God. Yeah, that's back to admit, when it's wrong.
Stop with something.
Yeah, tell me about it. I didn't really want to go through that.
What?
I actually thought about walking away, but.
What's it? It's bad, I think.
Oh.
It was most of them.
It's operate. Yeah, if you guys have them as a witness, I would. Cause every single time, just like the judge said, it's very difficult.
My trial's up for September 8th, and then
He's very obstinate and I don't know, tries different ways to think of how he can be, a jerk. Sometimes it bothers me, and the other day I was actually getting kicked out of it, so. I thought it was going to be like.
Are you guys recording?
She thought he'd push him somewhere and we can go to jail, but no, I won't do that.
I was in this side, I'm very frustrated. That whole hearing.
Oh, yeah. Well, I have some theories on why that happened like this. Only because I've been here a really long time, so you get to know people. Heck, I'm a judge, of course, you're the judge, so, you get to know how people think and stuff. If you wouldn't mind, would you send me like what your offers are for the PB people, and that way I can just try to talk, yeah, if you don't mind. I know that's a little list, but that way we can maybe. Expedite, there you go. Or at least know which ones we're gonna push on. kind of reminds me of when I was in high school English classes, senior, they had us, do some kind of speech and recording it. And so that we could watch it, and then of course, we would just eat it.
Right.
Yes.
So everyone likes.
And if I remember right, the speech was about what you wanted to do with your life
Yeah.
after high
Do
school.
you remember what you said?
Yeah, I wanted to be a lawyer. Well, there you go. Yeah, I know. I'm sure they didn't think so. It's amazing how, although I will say too, I've met a lot of people over the years that said they want to be an attorney, and I don't think, if you don't have a lot of drive to want to do it, it's not going to happen. No matter, even if you have the money or whatever.
It's not 100%, that's for sure what you want to do.
Yeah, or say, you ain't gonna stop me.
You will hate your life. Well, I hate your life mostly anyway. So
You might hate your life as a lawyer, you might hate everything, but you just keep doing it anyway. And next thing you know, you're old and you go down. So encouraging. Well, hey, it's not all bad. I mean, there's lots of good points in between. You gotta remind yourself of those. So I feel like a lot of my clients, I'm their therapist. So I have to be taking positive. I am, honestly, yes, I am optimistic, except probably about my own life, so. And it's only because I guess sometimes I forget, I am blessed. I gotta remember. That's
you want to be mindfulness.
that's right, that's right. And a lot of things that I'm dealing with, people be thrilled. I'm amazed how many clients, where it depends on what kind of clients you have. But a lot of clients that think we're going to the ocean and don't have a car or have all kinds of car trouble with these people. We just heard about and, so I'm blessed. I mean, like.
Yeah, it's Clinton.
All right, so I'm
gonna grab Dawn real fast. I don't sign this certain thing before he gets gone. How do I?
They're not showing. Listen, somebody's ceiling and top of their wall. That's. That could be, well.
I'm trying to figure out, I can't hear anything. Or maybe I'm not supposed to yet.
Yeah.
Kyle.
Usually got you muted. So. Yeah, it's not muted on their end.
Oh, that would make sense. Okay.
No, but you might want
Today. But with all this rain, I will. I'm gonna check it, just send me a little blurb that said. Wednesday, where can you see it? It is. Oh, that's us. Hi, Tom, is everybody here? Okay. Happy day. Wondering whether we're gonna. Let me know what have they do.
Hire your attorneys. You hiring your own attorney? I thought one of them was you. You have a name to take, correct? I'm assuming. That's enough. I need you to fill out these pieces of paper. That's not, that's not. I think so. Jeff, you and your client ready?
Which one does she want to do first? I got two.
Which one? Who do you got?
I got Starston and I have, Van.
All right, let me ask. But
They're both going to second.
source and arraignment too.
Yes.
Need
AG's office, this is the, Van.
Can you have stars and fill out this contact information so you don't do it?
Yeah.
You're right.
You too. Yeah. No, yeah, I'm gonna do it too.
I already had this made do it.
Oh, you did?
So he's good.
We'll probably do him first then.
Most likely, but I'll find out. All rise, please.
Well, Libby, nice. Thank you. Please be seated. And we have a special prosecutor on the case. With the professional courtesy, want to do her for which defendant? Okay, so hello, are you Assistant AG?
I am. Good morning, Your Honor.
Good morning. And that indictment.
State versus Bing.
On page 2 of our document, my goodness, there's a lot of cases today.
Or no, I think page.
Hmm. Well, why am I not finding it? Let me try again. Just give me his case number, please.
R094.
Find it that way. More than one way to skin cat. All right, we are on record in the Meigs County Common Pleas Court in the case of State versus Bing 26 CR 094. For the record, I'm Linda Warner, the Common Pleas Court Judge. If you would please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, please state your name.
Alan Boone.
Okay, you can put your hand down, and you filled out some paperwork that included your physical and mailing address, phone number, and email. Is that correct? Okay, so you've delivered that to the court. Thank you. And your attorney's going to identify himself.
Thank you, Your Honor. Jeff Finley, 435 Second Avenue, Yonkers, Ohio. My diligence will also be on this case with me.
Okay, thank you. And we have a representative from the Attorney General's office. She's going to identify herself.
Thank you, Your Honor. Caitlin Wilkin from the Attorney General's office, designated as a special prosecutor for Meigs County due to a conflict. There will also be Seth Enlow from our office, who unfortunately was not able to attend today, but will be making appearances in the future.
And how do you spell Seth's last name?
Enlow.
Okay, thank you. And he'll make an notice of appearance, correct?
He will, Your Honor.
Okay, great. So you were indicted by the Meigs County Common Pleas Court grand jury. Did he have it more than 24 hours ago? Does he want me to read it? Does he want penalties?
Sure, Your Honor, I'll address all of that.
Okay.
No, Judge, we'll waive any service requirement. He has not. We found out about it. I contacted the court yesterday to arrange for this arraignment. I appreciate the court accommodating us as well as Ms. Wilkin. So we'll waive reading the indictment as well as potential penalties as well as a recitation of rights and not guilty. Plead to each count. I believe there are 4 of these.
Okay, plea of not guilty, did you say?
Yes, sure.
Okay, so we'll enter pleas of not guilty and move on to the issue of bond. What's the state's position on bond? Well, first of all, I neglected to mention there obviously would be a victim or victims.
Our office.
Oh, you're not, okay, so that's a good point. I'm sorry. So was the victim notified of today's hearing?
They were, Your Honor, through our victim advocate services.
And are the victims present, or do you anticipate they would be present?
They are not present today.
And did you expect them to be?
No, Your Honor.
Okay, that's fine. So sorry about that. So next, let's move on to the issue of bond. So what's the state's position on bond?
Thank you, Your Honor. Your Honor, this matter initially came before the court in municipal court when it originally occurred. We got on the case and realized there was more investigation to occur. So the victim did seek and was granted a protection order out of Athens County under case number 26 DV 008 that was granted as a full on March 23rd of 2026 as the file stamp through March 6th of 2027. We are going to ask that any bond terms include that Mr. Bing, of course, follow the rules and guidelines from that civil protection order, but also ask that you impose a no contact order should this proceed longer than, of course, that date. And of course, she could always request that be extended, but we're going to ask for a separate no contact order through this court, including any third party contact, as the allegations in this case that concerned the state of Ohio is that in the days leading up to the aggravated burglary, the state anticipates that its evidence at trial is going to demonstrate hundreds of phone calls, text messages, social media contacts driving by the alleged victim's work and home multiple times, causing severe distress. So we are concerned about that ongoing through this case, particularly since now he has been indicted. Due to the level and those concerns, we're requesting that this court impose a $50,000 cash professional bond.
Okay, the defense position on bond?
Yes, Judge, thank you. I would like the court to know the history of this matter. Mr. Bing was charged by criminal complaint in Meigs County Court on February 9, 2026, with an F2 burglary, also a first-degree misdemeanor theft and a first-degree misdemeanor assault. He was arraigned on February 10th by Judge Barr. He was given a $25,000 10% bond, which he posted to $2,500 at that time. Preliminary hearing was scheduled for February the 12th. Mr. Bang and I appeared for that preliminary hearing. Mr. Stanley's office, the Meigs County prosecutor, determined at that time, or I think they were trying to sort out that they had a conflict. So that matter was continued, rescheduled to March the 6th of 2026. At which time Mr. Bing and I again appeared. And then at that time, Mr. Stanley's office had determined that they likely had a conflict and was going to seek the Attorney General to come into this case. So the preliminary hearing was moved to April 28, 2026. We waived time with respect to the preliminary hearing so we can have a preliminary. And that again was scheduled on April 28, 2026. Then the state, through the Attorney General's office, moved to dismiss this case on April 24, 2026. Mr. Bang and I again appeared on April 26, 2028, or excuse me, April 28, 2028, as
2026, you probably didn't appear in 2028.
April 28th of 2026.
Yeah.
We appeared for that preliminary hearing because there had been no order dismissing it. It was dismissed that day. So Mr. Bang appeared 3 different times. And then the case was dismissed by entry that day. So 6 months have gone by here with no allegations of any contact with the one alleged victim. I know there's been the plurality used here, but according to the indictment, there's one alleged victim here. So there's 6 months here. Mr. Bang is working right now. He's working out of local Union 168 in Marietta. Got a very good job. It does not require him to leave the state. That bond that has been posted remains over at county court. The $2,500, we didn't get that refunded or anything, but have that returned. I would ask the court to have that bond continued over here. What is interesting about all of this puffery about all these allegations leading up to the incident here is Mr. Bing was the reason Mr. Stanley's office has conflict is because Mr. Bing was a victim of violent crime, wherein the alleged victim in this indictment lured him to her home where he was beaten by her ex-husband and another. So that's just some background information, but Judge, I don't see any reason why that bond should change when he's been out here. If he was a threat to society or someone else, I mean, somebody would have expedited this, I would think. So he's been out 6 months since he posted the bond with no incidents. And I don't know anything about any protection order in Athens. I don't doubt that that's been, there. I wasn't his attorney on that, but we asked the court to continue the bond from county court. If there's any kind of violation or something like that, then toss them.
Okay, I do want to make sure that if there is a full civil protection order in Athens, that he has received that, because I can give him.
He was unrepresented. He went to the hearing.
So you did receive a copy of the full order that was for that 1-year term?
Yes, he
Okay,
does,
because if not, I want to make sure that happens today. So
He
acknowledges that he received it.
Can I say one more thing?
No, you want to talk to your attorney.
We will, but we have no issue with a no contact order and abiding by those terms of that protection order. He's going to follow the law. To request him to post additional bond on this doesn't make any sense.
Okay. All right, the court is going to continue the bond from county court, which I realize is a little somewhat less than what the state is requesting, and order it that it be transferred here, and going to emphasize that the bond money transferred here also has conditions that we typically impose in the cases, which means you cannot use drugs, alcohol, or other mind-altering substances, and you'll be subject to random drug screens throughout this period. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do anything with firearms during the pendency of this case. And you can't get any other trouble. No contact with law enforcement resulting in charges or arrest. If that would happen, you must notify the court immediately. And lastly, no contact with directly or indirectly. So you can't have any third party contact these people either. And I need their names.
Your Honor, the victim's name is Jasmine Tippy, JT, in the indictment.
And anyone else or just the one person?
The domestic order does include her 2 children, but under our case, I believe it's appropriate for her.
Okay, so again, emphasizing what your attorney's already indicated, that you are subject to a civil protection order, and a violation of that would result in additional criminal charges. So you understand the importance of not having contact. I'm also going to make it a condition of your bond that you have no contact with Jasmine Tippy directly or indirectly, or anyone in her household. Do you understand those conditions of bond, including and in particular the no contact order? Okay, so with that, then we'll also order that you have to be fingerprinted and photographed before you leave today. There probably is a representative from the sheriff's office here to do that. If not, they will be. And next we'll have some hearings, and they will be scheduled.
Sorry. What about September the 21st at 11:30 for an initial pretrial?
I'm not available that day, sorry. I am on the 28th.
What is it?
28th, 21st, I'm gonna be.
Okay, we will not have a judge here on the 28th. Are you out that whole week of the 21st or just the 21st?
Out the 21st, the 23rd, 24th. Be here the 22nd, the afternoon.
And we did schedule some things at 22nd, so we could do it.
You wanna go out to October the 5th? At 11?
I don't know what
Yeah, what's the
AG's
AG's office?
availability is.
But you would be good at that time.
I'm good on October.
We would be good on October the 5th. I don't know if the court would have availability in the afternoon. We might be pushing to get there at 11. It looks like we have potentially a 9 o'clock in a separate matter.
That's fine, we could do 1 o'clock.
That would be fine if that's acceptable to the court and defense counsel.
That's good for me, Jeff.
So, October the 5th at 1. What about November the 2nd for a final pretrial and motions hearing? At 10?
I'm good with that.
That also works for the state.
Okay.
November the 2nd at 10. And then what about a jury trial date for December the 1st?
That works for me.
And they're always, that will start at 8 a.m. for your client's information and for the state's information. So I assume, is that date okay for the state too?
It is, Your Honor.
Okay, so this will be all this information about your bond and the court dates and conditions of bond and so on will be on paperwork you received today when the clerk comes to get you, because even though we're transferring your bond, we'll still need to get your signature on some things. There's some bond information that I'm sure they'll need you to sign, and you have to get fingerprinted photographs. So you can't leave right after this because there's some processing that goes through. Do you have any questions? Is there anything else from the state on this matter?
No, Your Honor. Thank you very much.
Okay, thank you.
Thank you.
Thanks. And are you ready for your next one, or you need a few minutes? You had another one. Let me find it here.
Yeah, so Tracy's on her way over.
I'm sorry.
Tracy's on her way over. Fingerprints.
Oh, great. Thank you.
You're welcome.
Yes.
Yeah, it's just a process served for wholesaler.
Oh.
So he was served.
Okay. There you go.
Great.
Ready whenever.
They're on record.
We are on record in the Meigs County Common Pleas Court State versus Starostin, 26 CR 075. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name
Joe Harrison,
and spell that first name
IKHAIL,
and your last name, spell
STAROSTI,
it. Do it a little slower.
STAROSTIN.
Make sure that was correct. Okay, great. And you filled out some paperwork, or have you done that? That shows your name and address, both mailing and physical, and your phone number and email.
Yes.
Okay, so with that then, counsel's going to identify himself.
Thank you, Judge. Jeff Finley, 135 Second Avenue.
And for the state,
Yes, Sharon, James Stanley, Meigs County Crossing Attorney here in Bath City, Ohio, office Crossing Attorney Abigail.
and there would be a victim or victims in this case, is that correct? And was the victim notified or were the victims notified?
Yes.
Are they present? Did you expect them to be?
No.
All right, you were indicted by the Meigs County Common Pleas Court Grand Jury, July 1st, 2026. I trust you received a copy of the indictment? And was that a yes?
Yes.
Good, do real words. And was it more than 24 hours ago?
Yes.
Okay, and do you want me to read the indictment?
No, we'll wait, read the indictment as well as the potential penalties of restitution of rights as well. I've met with Mr. Starson a few times.
Okay.
Explain to him, I can explain that to him.
All right, and you're going to enter a plea?
Yes, Your Honor, not guilty, each count.
All right, and with that, then we'll turn to the issue of bond. What's the state's position on bond?
Yes, I'm gonna say recommend or bond in this case since Mr. Sarson appeared to sent to his summons.
All right, assuming no objection to that?
No, Your Honor.
Okay, it's a good thing to show up voluntarily and when they're scheduled. That goes to everybody here. Because that gives you a significant benefit, especially when you're looking at very serious felonies. Because the underlying charges involve serious felonies, you have to understand that once you sign the OR bond or personal recognizance bond, which you'll have to do before you leave today, which promises you'll come at each scheduled hearing. If after you sign that, you fail to appear, then you could be charged with an additional serious felony. Do you understand that? Okay, and also, you will not be permitted to use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, purchase, or attempt to do anything or possess firearms. And you can't get any other trouble. No contact with law enforcement resulting in charges or arrest. And no contact, I assume, with somebody? Anybody?
Autumn.
AUTN. Okay.
Carson.
Okay, and anybody else? Just okay. And I know you have a pending divorce. I'm aware of that. So extra condition of bond is you have no contact with Autumn Starson. And that excludes, though, you're allowed to come to your divorce hearings, you know, with your, do you have an attorney in that case? I forget. You do?
Mr. Cleveland.
Okay, so yeah, you would come and you'd be with your attorney. That's not going to be a violation, but any place else, you cannot be anywhere near her. If you go to Walmart and she's there, you leave immediately. You don't go to her house or anywhere near her house. You don't contact her directly or indirectly or have anybody else contact her. That's an additional condition of bond that's special in these types of cases.
What about that? I haven't BR property, which I'm taking care of that.
What are you taking care of on the property?
BR.
Yard.
Oh,
Is that for your divorce?
Yes.
Yeah, that's a temporary order.
oh, well.
This, they're registered to, you know, I'm at registered beekeeper instead of a hive.
Oh, beekeeper, not the bees. It's not. a
Yes,
beekeeper.
probably.
Can you
Just set up.
Take care of that.
Can you move the swarms to where you're at?
They're not swamped, they're in the hive, and I cannot do that till winter time.
Probably just gonna have to have somebody else that has to take care of them, because I assume, unless they're the state, I don't know how the state. Obviously, when we went through the divorce, this was not an issue.
I have spoken with the victim about that since he was allowed to come into the property to take care of these. as part of the divorce.
Mhm.
And she's indicated that he often comes in the house and just makes himself at home and does whatever he wants. So she doesn't want him on the property at all.
Mhm. And can or will she take care of the bees?
I would check with her on that, yeah.
Well, obviously, this no contact order is gonna trump anything in the divorce. There's no,
Scheduled to visit, to attend.
I was gonna bring that up next. So, but first of all, do you understand no contact on the property at all? And someone else is gonna have to take responsibility for the bees. So, secondly, I know you do have parenting time, at least with one of the two children. And how do you typically exercise that?
We exchange all at the parking lot.
But what parking lot do you exchange at?
We up and stuff. We've been by court order.
Where was it?
We up and stuff.
Oh, okay, that what used to be Whaley's
We
or not?
can't remember.
Oh, they're on 681?
Yes.
Okay, I think that was Whaley's, so, is that, what about contact for purposes of exchanging the child? Are you seeing the older child?
Now.
Okay, just, yeah,
I don't recall having any conversation with her about that.
okay, probably need to set that for a quick hearing to figure that out, because he's not old enough to drive or get there himself. If there were, I wonder if her parents or someone could facilitate that exchange instead of her. Maybe could you make some contacts about that? Cause I know that it does have parenting time with one of the children, and I don't want them to, the two of them to have contact, so. Also, I want to note for the record, I recall, of course, from your divorce hearing that English is not your first language, correct?
Yes, ma'am.
So your first language is? Okay, and you would have the right to have an interpreter and to interpret for you in court. Your attorney, I'm sure, is aware of that. If you need that, we can reschedule even the arraignment to take care of that. But Mr. Finley, I know
I
you.
don't think we need an interpreter for today's purposes, and we'll discuss that matter, Judge, but today, you understand.
Yeah.
Today.
Yeah, he was perfectly,
No,
he was perfectly fine.
Communicating.
Yeah.
And
He was great.
we get
and-
to trial or something, I'll have to maybe reconsider that. But as far as my conversations with him, I mean, I understand and he understands me, and he's been here 26 years in the United States.
Yes, so he can
He's a
understand.
US citizen.
Okay, yeah, we're gonna get to that. So, okay, so he can understand both the verbal and written English sufficiently.
Yeah.
Okay, so that we don't have to worry about interpreters at this point, at least. Okay, good. So the only thing is, how often are you having your parenting time with the youngest child?
Every other weekend.
Every other weekend? Is that like Friday night through Sunday night?
Yes, ma'am.
Are you texting or calling or? Okay, just go ahead and step out. We'll keep working on other things, but again, want to figure out a way to facilitate. One would be through the visitation center, but that costs money. You have to pay them for them to be there for exchanges. So if she could have somebody else that would bring him and pick him up. That would be
Yeah,
good.
I don't know any of the intricacies of. So,
Well, I've talked to him. I know the son wants to have parenting time with his dad, so. At least last I talked to him at the school some time ago. But do you understand the conditions of bond with the one thing that we'll have to clarify about your parenting time? Is that a yes?
Yes, ma'am.
Okay. And next,
So, I'm coming up this weekend.
okay, the lady that was here that I was talking to, she's what's called the victim advocate. So she's the person that's kind of the liaison, or the person that talks on behalf of the prosecutor with people that are victims of crime. She's going to reach out to her about my suggestion that a third party deliver and pick up the child at the designated parking lot. So if we can get that worked out, we'll include that information in this arraignment entry. But beyond that, we do need to set some hearing dates, and they will be.
You just wanna use the same dates we used for the last gentleman?
I do not want to double book a jury trial.
I know that.
The initial.
The initial works, yeah.
Okay,
That was October 5, right?
yeah, so,
What time on this?
you wanna do like
Same time?
1:15?
Okay.
We did one on the other one, so October the 5th at 1:15.
And that was with a special prosecutor, but
Right.
those days, okay, does that show prosecutors here?
October 5th?
Yeah.
Yes, okay, just want to make sure.
And then a final pretrial motions hearing for November the 2nd. at 11.
See, I would hate to have two motionaries the same.
Okay.
Okay, well, we'll look for a different one. That's fine. No problem.
I don't, honestly don't foresee any motions on either of these cases, but I don't have discovered that I know a lot of.
So do you want to have,
No, I, just in
Separate,
case.
just in case, okay.
Yeah.
What about November the 9th?
That works.
Okay, at 10.
Yeah, that's fine.
All right. A jury trial date of. What about December the 8th?
It's the last one.
Is that when I did the last one?
You did do it that date? Oh, I can't remember. I can
No,
look
that
up.
was
No,
the first.
Yeah,
just
you wanna do the 8th?
I mean, you don't know that they both go, but whatever, you know.
About 15,
Sure.
maybe 22nd, something.
Yeah.
December 15th at
You
8.
can do 22nd. Doesn't bother me any. Jurors will complain. They won't want to come in right for Christmas. And James will complain. Andrea will complain. No. All right, so you were shaking your head when you,
I was making. I called.
okay, so we'll have you stick around for a few minutes, but says did you leave voicemails? So presumably she will call you back, I would assume. If not, we'll schedule a very quick hearing just on the issue of that in your domestic case, but alternatives would be if she has somebody that can do the transportation during the pendency of the criminal case, or doing the exchange at the sojourners visitation, supervised visitation center. You wouldn't have to be supervised parenting time, but they could facilitate the bringing your child, mother bringing the child to that center, leaving, and then you coming 15 or 20 minutes later, picking the child up, and then doing the reverse of that on Sunday night. We can utilize them as an exchange. And that's here in the village. It's on the middle block here in Pomeroy, but it does cost. There's a fee associated with using the center. So that would be the alternative on at least a temporary basis till we could get a hearing set in their divorce about that limited issue.
My understanding, the divorce on the inactive time. That's what Mr. Cleve indicated to me.
Why would it be on the inactive docket?
So you put it on. Told me.
Oh, wait, there's no reason why we'd have it on inactive docket. Look and
I
see.
mean, I don't know, I just was talking to him about status.
I believe so. Let me pull it up. I mean, unless they're in bankruptcy. Is there a bankruptcy?
No,
We would be, have a stay
yeah,
because of that.
that's one reason, that's what it.
Pull it up. And then we put, discovery deadlines and some things like that on.
Unless he means there's no final hearings.
Final pretrial statement, and you wanted me to talk to the children, which I did. There's a final hearing set for April 30th.
Okay, so April 30th, 27th.
No.
Oh, no, I'm so sorry. Yeah, that was when it was originally set. Let me keep going forward. Good point. The motion to continue by a bunch of people. Journal entry. So this was July of 26. It did go on because there was a request to stay because of this criminal case, because he would not be able to testify at deposition. So and I just had forgotten about that. So a stay was put on July 13th, so about a month ago, basically saying the divorce is on hold because discovery can't be completed, because presumably her attorney may want to ask you questions under oath, and your attorney in your criminal case is going to direct you to probably not answer much under oath, because anything you say there could be then used against you in this case. So I do see that did happen, and it was agreed upon that we would put a stay on it for that purpose of getting through the criminal case first. So I'm glad you pointed that out, because frankly, I didn't remember that separately from all the other divorces we have pending. So we still need to take care of his parenting time though. So as soon as you hear anything back. Is there anyone in her family that you can think of that gets along well with her and still has a relationship with you that she would trust to bring your son back and forth?
Uncle, mom,
Do you have relationships with them still?
with her uncle, yes.
That would be, which uncle?
Jack, well,
Jack? Well, just for purposes of the victim talk. So does he live close enough and have the flexibility that he could pick up your
Yeah.
son? If he would be willing to do that, or her dad, did you say, or her mom? Okay, okay. So, but she'd be fine with you.
oh, God.
Okay, well, I want somewhere there'd be no
Yeah,
conflict.
that would be Jack Well.
If he's willing to do it,
Yeah, he will.
he'll be willing, okay. So that might be an option for her. And she gets along with her uncle?
Yeah.
Okay, okay, good, okay. Just stick around until we get some word back on that, and you're also gonna have to be fingerprinted and photographed. All right, anything else we can do? It's up to you. Knowing that's the only issue you can, I'm hoping we'll get an answer
If she
quickly.
gets, you get an answer, you're gonna incorporate that into the entry.
Yes, right, so we won't do the entry until. And you're also, it has to be fingerprinted and photographed before you can leave anything.
Okay.
Did you have any other suggestions, Mr. Finley, to resolve that issue?
No, I don't have any, I don't do domestic work.
I know, you don't like
want
that
to
stuff.
talk.
Don't even want to talk about it. Okay, that's fine. Well, you'll have,
Sadly, I've been rubbed in Jack's things together.
oh, thank you, Judge. All right, so we'll just have you have a seat because you're gonna have to be fingerprinted and have to wait on what we're gonna do for your parenting time. All right, who do we have next?
I think there's a Shane Vandermeek here. I'm not sure how to pronounce the last name.
Okay, I'll find it here and I'll give it a try.
He's number 2672.
Okay, so state versus Vandame. Come on up. I don't know that I pronounced that correctly and I apologize if I didn't. Go ahead and have a seat, sir.
On record.
We are on record in the Meigs County Common Pleas Court in the case of State versus Vandame, 26 CR 072. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I'm sorry?
Yes, ma'am.
Okay, state your name. And you spell that? Thank you. And you fill out a piece of paper with your name and address, phone number, and email. Is that information on that paper accurate? What do you mean exactly as you can?
I'm working. We're at a month down, so.
Oh, okay, that was on your that's a different, so you fill out two forms, right? So first I'm calling your attention to the one that had your name and your address. And is that an accurate address? Both, I need both physical and mailing, so the clerk has, they're the same. Okay, great. And the separate form, if, did you say your house is paid for, so you put 0? So that's fine. That's on your form for if you want to get a court appointed counsel. So with that, then we do have your information and we have the state who's represented by.
Yes, Your Honor, James Stanley, Mexican prosecutor in Congrats of the state of Ohio, along with Assistant Prosecutor Abigail Gopi.
And given the nature of the allegations in the indictment, there would be a victim or victims. Were victims notified?
Yes.
Are victims present? Did you expect them to be? Okay, so Mr. Vandam, you were indicted by the Meigs County Common Pleas Grand Jury on July 1st, 2026 on 2 counts, count 1 rape, count 2 gross sexual imposition. I trust you received a copy of that indictment. Was it more than 24 hours ago that you received it? Okay, you have the right to have the indictment read to you in its entirety, word for word, or if you're good at reading and understanding written English, you may waive the reading. Do you want me to read it to you or do you want to waive the reading? Okay, I will tell you, because you don't yet have an attorney, count one, as I indicated, is rape. It is a felony of the first degree, which carries a mandatory prison sentence. So if you're convicted, you will go to prison on that no matter what. And the term of prison can be anywhere from 3, 4, 5, 6, 7, 8, 9, 10, 11, up to 11 years definite, because it's a felony, the first degree, and up to 16 and a half with what's called the tail indefinite. So 11 to 16 and a half years in prison for the rape, up to $20,000 fine, or both. Do you understand the potential penalties for count one, rape? Count two is gross sexual imposition. It is a felony, the third degree, which carries its own potential penalties of 9, 12, 18, 24, 30, up to 36 months in prison, up to $10,000 fine, or both. Do you understand the potential penalties for count two? Obviously, it's very, very serious, and you need to have an attorney. I'm going to enter a not guilty plea on your behalf and this time, and you need to have an attorney. If you cannot afford one, one can be appointed. Are you going to hire your own, or you need one appointed? You're gonna have to speak up.
I'm sorry.
You're gonna need one appointed? Okay, we'll have one appointed.
Lee Roberts.
Attorney Lee Roberts will give you his contact information. He'll be appointed. Next, I'm sorry. Okay, next we'll talk about bond. What's the state's position on bond?
Yes, Your Honor, despite this being very serious allegations and a number of reasons the state asked for summons in this case, and he did appear pursuant to that summons, so we'd ask for another bond.
Okay, that's quite unusual, given the nature of the charges. I typically would set a very, very high bond. I assume you're gonna want no contact with victims. Are they minors?
Yes.
So we need initials. I'm sorry,
NJ.
N as in Nancy, J as in Jeff. Okay. Same victim, both counts, okay. So the state is asking that you have an OR bond, personal recognizance bond, for you voluntarily showing up today and for other reasons. So I assume you have no objection to that. So you're going to have to sign that bond today, and you're not going to be able to leave until after you sign it. But because your underlying charges are very serious felonies, you must understand that once you sign the bond, if you fail to appear at any scheduled hearings, you could be charged with an additional serious felony. Do you understand that? Also, during the pendency of the case, you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms. And you can't get any other trouble, no contact with law enforcement resulting in charges or arrest, and no contact directly or indirectly through anyone with the victim, in this case, with the initials NJ. And you know who that is. Okay, so you understand the conditions of bond? Okay, next we'll talk about a scheduling order.
We will set an initial pretrial for September the 22nd at 1:30. The final pretrial and motions hearing for October the 27th at 1:30. And then a jury trial date of November 17th at 8.
Those dates will be on the paperwork you'll get today, what we call an arraignment entry. You'll also have an order that you have to be fingerprinted, photographed, and DNA taken today before you leave, and that's set up in the clerk's office. So that'll happen on this floor here before you leave. Make sure you read the paperwork because it has all those conditions of bond, and you'll have to sign your bond, of course, too. Do you have any questions? Anything else from the state?
No, Your Honor, thank you.
All right, just go ahead and have a seat. I'm watching for these to be processed, these entries to be processed. So as soon as it appears, I'll be signing it, and a clerk will come in to get you, or the bailiff will take you for fingerprinting. Thank you. All right, who do we have next?
Okay, I'll see if I can.
Who do you want next?
Canterbury.
Okay.
State versus Canterbury.
We are on record in the Meigs County Common Pleas Court in State versus Canterbury, case number 24 CR 074. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth will help you God? Okay, if you would please state your name
Jessica.
and you filled out some paperwork that have accurate information as to a physical address and a mailing address and a phone number and an email.
Yes.
Okay, and we're gonna talk about getting you an attorney in a moment, assuming you're gonna need one or we'll ask who you're gonna hire if you hire one. In the meantime, though, we're gonna have the prosecutor's office introduce themselves, whoever it is gonna be.
Yes, Your Honor, James Stanley, Meigs Common Pleas Court here in the state of Ohio, along with Assistant Prosecutor Attorney Abigail Guppy.
All right, and you're here because you were indicted by the Meigs County Common Pleas Court Grand Jury, July 1st, 2026. It's a one-count indictment. I trust for possession of drugs. I trust that you received a copy of that. Was it more than 24 hours ago that you received a copy?
Yes.
And you have the right to have the indictment read to you in its entirety, word for word, but it's a right that you can waive if you want to, if you're good at reading and understanding written English. Do you want me to read it to you or do you want to waive the reading?
Oh,
Since you don't yet have an attorney, I am going to tell you possession of drugs as charged here, specifically fentanyl in an amount, makes this a felony of the 5th degree. A felony of the 5th degree carries potential penalties of 6, 7, 8, 9, 10, 11, up to 12 months in prison, up to $2,500 fine, or both. Do you understand the potential penalties for count 1? Obviously, it's very serious and you need to have an attorney to assist you. If you cannot afford an attorney, one can be appointed. Are you going to hire your own or you need one appointed? And you filled out the paperwork for that too, and we'll appoint
Lee Roberts.
Attorney Lee Roberts. And there's his contact information. Next, we'll talk about bond. What's the state's position on bond?
Yes, Your Honor, state records,
Okay, that's also, as I mentioned earlier, quite a privilege when you have a felony, so I assume you have no objection to that. Okay, let me re-explain to you what you've probably heard me say to other people. An OR bond is a privilege with a felony and you have to sign. Once you sign for that OR bond, you're committing yourself that you will be at each scheduled hearing. Should you fail to be at any scheduled hearing, then you could be charged with an additional serious felony. Do you understand that? Also, you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to and receiving random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms, and you can't get any other trouble. No contact with law enforcement resulting in charges or arrest. And are you currently at Field of Hope? Yes. So I'm going to make an additional condition that you would remain at Field of Hope and in full compliance with the program and signing a release, because in lieu of the pretrial services we would be offering here with you meeting with Brittany and having regular drug screens, we would like to know about your progress at Field of Hope and what those drug screen results are. So that'll be an extra condition of your bond. Do you understand that? Yes. Okay, and then we'll have hearings on.
We will set an initial pretrial for September the 22nd at 1:45. The final pretrial and motions hearing for October the 27th at 2. And then a jury trial date of November 17th at 8.
And those will all be on paperwork you'll get today. That's all actually on the second page. The first page will have your attorney's name and contact information, plus you were just given a card. We'll also have the bond and the conditions bond on the paperwork. Do you have any questions about the bond or the conditions or the scheduling order? Okay, lastly, there will be an order that you have to be fingerprinted, photographed, and DNA collected today before you leave the courtroom. So you're gonna have to make sure you sign your bond and have that fingerprinting process done before you can leave. Okay, anything else from the state?
No, Your Honor.
All right, then go ahead and just have a seat in the courtroom. We're watching for those entries as they come, then the clerk will come and collect you. Thanks. Who do we have next?
Not back from the Western Village.
Okay. Do we have any others here that are here for arraignments still? Yes, ma'am. Did you check in yet?
She did not.
We're gonna come in here. You can have to
What's your name?
Beaver.
McKeever? Okay, we'll get you some paperwork. So we can get you started. Well, do you just stay there? I heard a big sigh from Liberty about behind me here.
Judges, Mr. Williams.
Okay. Well, she's filling out the paperwork. I can do that.
Yeah,
Yes.
your hands first, then.
Yeah, see, I still.
And he has 3 cases, Judge.
Okay, and this is Mr. Williams. 3 cases, 26 CR 066, 26 CR 071, and what's the other one?
CR 073.
Those indictments pulled up real quick.
One.
All right, I'm ready.
Here, on record.
We are on record in the Meigs County Common Pleas Court in State versus Williams, 3 different cases. They are cases number 26 CR 066, 26 CR 071, and 26 CR 073. For the record, my name is Linda Warner. I'm the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, state your name. You're gonna have to speak up.
Randy Williams.
Okay, and you were indicted in 3 different indictments, the case numbers that I just read. I trust you received, well, I'm getting ahead of myself. You filled out some paperwork, right? That had your address, phone number, and email? Just, okay. And is that information accurate? If it's changing at all, you need to notify us in writing if any of that information changes. And then you don't have an attorney yet. We'll talk about getting you on a moment. We do have the state's attorney who's going to identify himself.
Yes, sir. James Stanley, Mexican prosecutor in Ohio. Along with assistant prosecutor, I plead guilty.
Okay, and if I look again, I don't believe there's any individual victims in any of these cases. So you were indicted by the Meigs County Common Pleas Court grand juries on July 1st, 2026, in those 3 indictments. I trust you have received a copy of those 3 indictments? Oh, you did not. Okay, so you did, how'd you know? You just look online and see? Okay, so what we're gonna do is we're gonna have ask Andrea to help me print out a copy of each of the 3 indictments, and I'm gonna give you a little bit of time to read through those, and then we're gonna turn the record back on. After you read through them all, then I'm gonna ask you if you want to waive the 24-hour rule, which means you have the right to have the indictment in your possession, to have received it and have it for more than 24 hours before we do the arraignment, like you've been seeing going on. However, that's a right that you can waive if you want to. And if you waive it, all that's going to happen is what you've been watching here. That is that we'll get you a court-appointed attorney if you need one. I'll tell you what the potential penalties are. We will set a bond and schedule hearings. I'll read the indictment to you and tell you the penalties if you need all that, and you'll get fingerprint and photographs. So that's all that will happen if you waive the 24-hour rule. But first, I want you to be able to first read through the paperwork and before you make that decision.
I did go online, you look at docket numbers and stuff, so I got a gist of like.
Okay, so you've looked at them online. You did, okay.
To whatever extent that allowed.
Sure. Well, you would have had full access to the documents because these are publicly viewable, but we're still going to want you to look through, make sure those are the same ones you looked at. There are 3 different cases, and then you'll be asked whether you want to waive the 24-hour rule. So go ahead and look through those and tell me when you're done. Because we had a special prosecutor on that one, or did you gonna do the entry for her? I mean, we need, if you don't mind, and you might just, even put a little caveat, you're doing this at the court's direction, even though the office has a conflict, because I should have directed the AG's office to do it. They're not familiar with our forms though, so if you could do that, that would be great. Have you had a chance to look at those, Mr. Williams? Okay, and do you want to waive the 24-hour rule and go ahead and have your arraignment hearing today? Okay, so you do waive it. You also, as I indicated, have a right to have the indictments read to you in their entirety, word for word. But again, it's a right that can be waived. Do you want me to read it to you, or do you want to waive the reading?
No.
Okay, so I will tell you the potential penalties, so you don't have an attorney with you for the arraignment. In case number 26 CR 066, it's account 1, possession of drugs, specifically methamphetamines. It's a felony of the 5th degree, which carries potential penalties of 6, 7, 8, 9, 10, 11, up to 12 months in prison, up to $2,500 fine, or both. Do you understand the potential penalties in that case? Count, and then in case number 26 CR 071, count 1 is trafficking in drugs, specifically methamphetamines. It is a felony of the 4th degree, which carries potential penalties of 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, up to 18 months in prison, up to $5,000 fine, or both. Do you understand the potential penalties for count 1 in that indictment? Count 2 is possession of drugs, specifically methamphetamines. That is a felony of the 5th degree, with potential penalties again of 6, 7, 8, 9, 10, 11, up to 12 months in prison, up to $2,500 fine, or both. You understand the potential penalties for count 2 of that indictment. Sure. And the 3rd indictment, which is 26 CRZ 73, possession of drugs, specifically fentanyl, is a felony of the 5th degree with its own potential penalties of 6, 7, 8, 9, 10, 11, up to 12 months in prison, a fine of up to $2,500, or both. Do you understand the potential penalties in that indictment? I'm going to enter a not guilty plea on your behalf, and it's obviously very serious, and you need to have an attorney. If you cannot afford one, one can be appointed. If you need one appointed, and you fill out the paperwork for that, so he appoint
Britt Wiseman.
Attorney Britt Wiseman will be appointed, and we'll give you his contact information. Next, we'll talk about bond. What's the state's position of bond?
Yes, not say bonds.
It's good that you showed up and, read things and knew you were supposed to be here, because for whatever reason, you didn't get the mail, or maybe was it sent to a different address? Did you look?
Well, yeah, I was in jail for, like 90 days, and I don't have it during that time.
But you gave us a good address where you can get things.
I have changed my address since then, so I don't have, they just didn't have the common record or what.
But the address you gave us today is accurate and where you're gonna be. Okay, good.
It's been changed for a while. I don't know why they went to the previous address.
Okay, but that's where it went to the previous address.
Seems.
So, you'll have to, it'll be your job to keep us up to date. If you change that address, phone number, email, that you show us that change in writing, if that should happen. Also, so I'm going to give you that OR bond because the underlying allegations in each indictment involve felonies. You have to understand that it's a privilege to get an OR bond, that once you sign that signature promising to attend all hearings, if you would fail to attend any hearing, you would be charged with an additional serious felony. Do you understand that? And other conditions of bond are that you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms. And you can't get any other trouble, no contact with law enforcement resulting in charges or arrest. You will have to meet with a pretrial services person in our probation department today before we leave, in addition to doing the other things we talked about, which is signing the paperwork and the photograph, fingerprint, and DNA collection. So we'll talk a little more about that in a moment, but in the meantime, we'll get some hearing dates.
We will set an initial pretrial for September the 14th at 2:45. A final pretrial and motions hearing for October the 19th at 1. And then a jury trial date of November the 10th at 8.
That October 19th. I won't be here. So, oh, we'll have another judge though.
Yeah.
Yeah, because we're gonna have a visiting judge. Okay, that's fine. No problem. Those dates are all going to be on the arraignment entry that you'll get today. It's going to be on page 2 of that arraignment entry. Because of the nature of these involving drugs, if you need any help getting some treatment, if you have an addiction issue yourself, we'll be glad to help you with that. Find outpatient or inpatient services based on your own need. You need to get an assessment, and we have a number of both non-faith-based and faith-based that we could refer you to that would help you get you in better position to work on these charges. So I'm gonna have you meet with Brittany today before you leave. You also, as I said, have to sign document promising to appear, and you have to be photographed, fingerprinted, and DNA collected. Anything else from the state?
No, you're, thank you.
Do you have any questions, sir? Okay, so just have a seat in here as the paperwork comes through. The bailiffs helping circulate everybody where they need to be.
Okay, next one, send back information first. then-
I'm sorry, I'll put probation first. Okay, it's fine. Just understand he can't leave till he signs his bond. Used to be, I was always, there was some black hole, people would disappear once they left this room. After arraignments, not really done.
You can come on up, ma'am.
Ms. McKeever,
Yeah. Let me give you a form for out. Okay, her now.
that's fine. You just sit right there, ma'am.
Here, on record.
We're on record in the Meigs County Common Pleas Court in State versus McKeever, 26 CR 068. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you have to speak up, but tell me your name.
Jamie McKeever,
And spell Jamie.
AMIE,
Okay, and McKeever.
MCKEE, V as in Victor, ER.
Okay, V as in
Victor.
Victor. Okay, make sure it wasn't Baker, B as in Baker. I thought it was V. Okay, you don't have an attorney. We did get your information you just signed. Was that information about your name, address, phone number, and email accurate?
Yes.
Okay, and we're gonna have the state's attorney introduce himself.
Yes, sir. James Stanley, Meigs County Prosecutor here in the state of Ohio, along with Assistant Prosecutor Attorney Avenue. Okay.
You were indicted by the Meigs County Common Pleas Court Grand Jury on July 1st, 2026. It's a 1-count indictment. I trust you received a copy of it. It was more than 24 hours ago that you received a copy.
Yes.
You have the right to have the indictment read to you in its entirety, word for word, but it's a right that you can waive if you're good at reading and understanding written English. Do you want me to read it to you, or do you want to waive the reading?
I want to read it.
Okay, I will tell you, since you don't yet have an attorney with you, it's a 1-count indictment for possession of drugs, specifically methamphetamines. It's a felony of the 5th degree, which carries potential penalties of 6, 7, 8, 9, 10, 11, or up to 12 months in prison, a fine of up to $2,500 or both. Do you understand the potential penalties for count 1? Obviously, it's very serious. I'm going to enter a not guilty plea on your behalf, and you need to have an attorney to assist you. If you cannot afford one can be appointed. You filled out some paperwork, so you want one appointed? Okay, we'll appoint
Denise Bunn.
Denise Bunce. We'll give you her contact information here. Next, we'll talk about bond. What's the state's position on bond?
Yes, sir. State recommends an oral bond.
I assume you have no objection to an OR bond?
No.
I understand and have heard probably that's your signature as your bond promising you'll appear at all scheduled hearings. Because the underlying indictment is a felony, you have to understand that once you sign, if you fail to appear for any scheduled hearings, you could be charged with an additional serious felony. Do you understand that?
Yes.
You also cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. Your firearms disqualified. You cannot own, possess, acquire, use, or attempt to do those things with firearms. And you can't get any other trouble, no contact with law enforcement resulting in charges or arrest. Do you understand those conditions of bond?
Yes, I do.
You're also going to be ordered to participate in pretrial services with our probation department because of the nature of the charge. And as I had indicated to someone earlier, if you have any drug addiction issues yourself or substance use disorder problems, we want to help you address those so you're in a better position as you go through this process. We can refer you to both outpatient and or inpatient facilities in the region.
I'm actually about to complete my
stuff through task down here.
Okay, so you are getting some help through
Yeah,
task?
I think she was already sending it to Brittany because
Okay,
she kind of knew everything that was going on. So,
okay, so you're meeting Jackie maybe there? or-
Yeah.
Okay, so if you haven't signed with Jackie, so she can communicate with Brittany, you're gonna tell Brittany that here in a few minutes when we have you go meet with her.
okay,
All right, and then, do you understand all the bond conditions?
yes.
Okay, we'll do some scheduling then.
We will set an initial pretrial for September the 16th at 9. A final pretrial and motions hearing for October the 28th at 10. And then a jury trial date of November 24th at 8.
I appreciate, and you're writing those down and getting those ready. You'll also receive that on the paperwork you'll get today.
Okay.
And they'll also be ordered that you have to be photographed, fingerprinted, and DNA collected before you leave today, and that will hopefully all take place right here in the clerk's office. Any questions?
I mean,
Anything else from the state?
No, you're.
All right, just go ahead and have a seat. As the paperwork's getting processed, you'll be called out.
thank you.
And Cassidy may have you go meet with Brittany before you leave as well.
I have. Thank you.
Thank you. All right. Did you ever hear anything on?
I did, I'm like, that's not even on me.
Okay, so, I don't know if Mr. Starson, her mother will do the exchange. We'll put that in the paperwork, just don't communicate at all. Your son's big enough, he can get out of grandma's car, get with you, and then get out of your car and get with grandma on Sunday night. So we'll put that in the paperwork.
Okay.
But have you signed your bond? Have you signed any paperwork?
No,
Okay,
paperwork's not done.
so still have to wait, even though we have that information, because, yeah, paperwork's not done, because we're waiting on that.
Right.
Yeah, okay. Anyone else here for arraignments? Just here observe, okay. Oh, the person that's on here, I wondered if he was just watching. Okay, what's your name, sir?
Oh, he's muted.
You're muted. I can try to unmute you. We might have I probably have to do that. So now try to push there you go. All right, what's your name, sir?
Clinton Olinger.
Olinger,
Clinton
okay.
Olinger, Your Honor.
Oh, yeah, he was on arraignment at 9.
Okay, Mr. Olinger, sorry, I thought you were just, I didn't know. I thought you were just watching. But some people do. No, that's fine. Get your case pulled up. Found over, there's the index. All right, I'm ready whenever you turn my record back on.
We're on record.
We are on record in the Meigs County Common Pleas Court in State versus Olinger 26 CR 062. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay. Tell me your name.
Clinton, Clinton, Olinger, Ohlinger.
And we're gonna need you eventually to give us the name, phone number, fax, email for someone there. You're at a facility, I take it?
Yes, ma'am.
At that facility where we can have you fill out some paperwork, including your name, current address, mailing address, email and phone number, with also the obligation that you're going to have to notify the court and the clerk in writing if and when that changes. So make sure you get that done before you leave that room, if you would. Next, we'll talk to the state about who's representing the state.
Yes, Your Honor. James Stanley, Meigs County Prosecuting Attorney. Here on behalf of the state of Ohio, along with Assistant Prosecuting Attorney Abby Ogilvie.
All right, Mr. Olinger, you were indicted on July 1st, 2026 by the Meigs County Common Pleas Court Grand Jury. It's a 1-count indictment for failure to notify change of address. Do you understand that's the indictment?
Yes, ma'am.
And did you receive a copy of the indictment?
Yes, ma'am.
Was that more than 24 hours ago?
Yes.
And you have the right to have the indictment read to you in its entirety, word for word, but that's a right that can be waived if you feel comfortable reading and understanding written English yourself. Do you want me to read it to you, or do you want to waive the reading?
Waive the reading, please.
Okay, I will tell you, since you don't have an attorney with you today, that it is a felony of the 4th degree, which carries potential penalties of 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, up to 18 months in prison, up to a $5,000 fine, or both. Do you understand the potential penalties for count 1?
Yes, ma'am.
Also, it's obviously very serious, so I'm going to enter a not guilty plea on your behalf, and you need to have an attorney to assist you. If you cannot afford one, one can be appointed. Are you going to need one appointed?
Yes, ma'am.
So there'll be some paperwork you have to fill out for that, but assuming you're eligible, we'll appoint
Bert Wiseman.
Attorney Britt Wiseman. His contact information will be on the arraignment entry today. And then we'll talk about bond. What's the state's position on bond in Mr. Olinger's situation?
State recommends no bond in this case.
Okay. State is recommending an OR bond, given the serious nature that this, I want to impress upon you, because the underlying charge is a felony, that once you sign an OR bond, you obligate yourself to show up at any and all hearings that are scheduled. And if you fail to show up at any scheduled hearing, you could be charged with an additional serious felony. Do you understand that?
Yes, ma'am.
Okay, and so that's another thing you'll have to sign before this is actually officially, this hearing is done. So the other conditions of your bond are that you cannot use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms, and can't get any other trouble, no contact with law enforcement resulting in charges or arrests. Also, if there was any no contact orders or post-conviction no contact orders, you have to continue to abide by those with whomever the victim or victims were in your underlying case. You understand that?
Yes, ma'am.
And what facility are you in?
Hope Valley and Circleville.
And are you planning to stay there for a significant duration?
I'll be here until Friday, and then I'm going to what is it? Lighthouse in Lancaster, Ohio.
Spell that.
Lighthhouse in Lancaster.
Okay. Is that a halfway house?
Yes, ma'am. Sober living.
Oh, it's a sober living. Okay, sober living house.
Yes, ma'am. Yeah.
And so you'll need to get us the exact address, phone number, email for that facility as well. Do you have a home address that once you're done with all the treatment that you know where you go, or is that part of what you're going to be working with the facility, getting you an address?
Yeah, that's what I'll be working on at the facility.
Okay, so I'm going to make a condition of bond that you remain at Hope Valley until or unless they move you to the other house in Lancaster, and that then you remain at the other house in Lancaster until further order of the court as a condition of your bond. So you can't walk away from the facility. If you do, then there'll be a warrant for your arrest, and you'll be brought back in, and a cash bond will be ordered. Do you understand that?
Yes, ma'am.
Okay. And did I already tell you can't use drugs, alcohol, or other mind-altering substances, and your firearms disqualified? I think I did already go through that. I've done it too many times today. Do you understand those conditions?
Yes, ma'am.
Okay. And next we'll schedule some things.
We will set an initial pretrial for September the 9th, or September the 14th at 1:45. A final pretrial and motions hearing October the 19th at 2. And then a jury trial date of November the 10th at 8.
Okay, those dates are all going to be on an arraignment entry, and I do need to find out where we can send all this paperwork and whose care, an email address or a fax, whichever's more convenient. So is there someone there with you?
Yes, ma'am.
Okay, so who would we send it to?
Hi, I'm his case manager. I've been working with Mr. Olinger for about 40 some days.
Great.
I've made contact with his probation officer, Cassidy, so he has all my information, but I could give it to you if needed.
Yeah, at least your email, because we want to get everything sent from the clerk to you so he can sign everything he needs to sign and have it sent back. So if you don't mind, I'd appreciate it.
Yeah, so it's the letter C, as in robot, TSHO as in orange, R as in robot, N as in Nancy, at Hope Valley, HOPEVALLEY recovery.com.
Okay, so it's Shorn, CHARTSHORN.
Yes.
Okay. And C as in Charles is the first one, right?
Yes, ma'am.
Okay, that's fine. Well, like I said, there'll be at least 3 documents that'll come. It'll be the bond that he'll have to sign. It'll be his identifiable information that includes his name, address, phone number, email. And if you would go ahead and say after Friday, the sober living address that he'll be at in Lancaster. And also he'll have to fill out the paperwork for eligibility for court-appointed counsel, which is a 2-page front and back or 2 pages, depending on how you receive it and you print it, I guess. And the entry he'll receive today from the clerk saying what would happen today, what his dates are on page 2, and so on. So if you can help facilitate that, we appreciate it.
Yep. Yes, ma'am.
All right. Do you have any questions, Mr. Olinger?
No, ma'am.
All right. Thank you for patiently waiting. I thought you were just watching for somebody else. I would have probably put you in sooner. I'm sorry. So, all right.
No problem. Thank you.
All right. Do we have anyone else?
So,
No, I think so. Yeah.
but he's aware that Mr. Wright did show up.
Oh, he is here. And he needs screened.
He was
And
the.
good. Good.
This, come on now.
Huh?
Come on now.
No, that's wonderful.
Got this. She was currently meeting with another one back there though.
Wow, 1800.
Or is the state ready to go on right?
No, he has not met with Denise. Denise is still meeting with inmates for the later hearings. That's why I made her aware that he is here. So would you like me to grab her and kind of?
You did tell her though that he's here?
I told the CO back there to make her aware because she was currently meeting with a client.
Probably, yeah, if you
But I
would
can-
tell her and just tell her, yeah, we're gonna, since that was scheduled.
Yep.
We want to get on that as soon as possible. Yeah, do you mind? Thank you. It's something about it's latching wrong or something. Jim's supposed to work on it, of course. He's sick. I'm sick today. We got it. Okay. Figure it out. I don't know why that door's doing that.
You know,
Somebody thought it was something
Yeah,
that actually.
huh. Did that for it?
right, I'll step out. I'm ready whenever Ms. Funds gets Mr. Wright ready. Cause that was scheduled at 8:30. 10:30. Come on. Oh.
Yeah. You get ready to get on the way. Thanks.
Essentially, sometimes there are people on the news, they were even graphics. Well, you can do that. Well, come on. So. Well, he left, you just, this was for that. Or did he come to see the which months after that? I don't think he did. That would have probably helped a lot. So any future. Oh, yeah, and that does happen, sure. But what happens is they look at it, not going to jail, you find a way. You know, you law. Well, you know, if you don't mind going to jail, then I guess, and that's how they look at it, go to jail. I don't know, I haven't had that happen to me yet, but I've had to have times where I didn't have my lawsuits, things, not the class, and that's gonna have that. But like I said, now they do have also a public transportation system. With that, yeah, use, the last time you probably think of it, next year. Are you with that? I'm doing it. Because I told him about it, even though it's not so to, I don't know, that has that number on it, because that might be an option for the future. Well, in the STAR program, they're recommending max size, basically, that's what they're thinking. In the STAR program, I think that I'm served there, it's based on how operations of everything you're supposed to be thinking more likely to not have to, you know, some of them I'm kind of may not be. But it's roughly how much I get that. Well, then, I mean, that's, so what happens is even the art do it. But it will be a two judge, it's not chief laws. And the judge for which not so usually we put this in I understand to have the ability of one to help them to this position, on the best case and see. What you do, having lost out with. See. Me too. Somebody the last message I was talking to was good. I know what you last message was. We can. Lisa. What's. Sure. And that's so right. I had talked to Mr. I haven't seen this steel or Mr. And they're not, because they're all these random different houses. Yeah, figured, no, that's all right, that's, I understand. We used to have those public transit cards, maybe they're help. I'm sorry, what you said? You need to be screened. He already did, and he's clean. Oh, I should look sorry. Just thought we did that already. Yeah, after we, and they did. Since I never seen him. Okay, I told Mr. Shem, I think that since the effort from me, that's probably. We were talking. Do you hear anything about where Mr. Chamber or Miss Steele is? Is there such for this 19? I believe they're both in June. And I'm not certain, I'll probably want to check. I heard some, yes. I responded and I thought I had somebody at the door, so I was waiting to see if the door was gonna come open before I opened it. Whatever, so. Yeah, we like the. But he's upset that they said that. He said that was a similar story to what somebody said when he was in the Athens for some reason. Maybe to like, you're just telling a story. I have one again. Ultimately was. Changing. He just changed. So, also, he's like, oh, yes, so I guess that's not his issue. Well, I don't know, I didn't know. Everyone, the two ladies are probably just go something down and nothing in it. Yeah, I texted they can still, because it looked like she was still in when I looked onto the phone line. Feel like I should go, hi, everybody out in the world is watching me. Yeah, sorry, I was just Brittany to see. Hey, my family watches.
All right, please.
No. Not anything.
No, of course not. Good to be placed. Thank you. Please be seated.
I did not have to fill one of these out.
Did you see I printed out new ones that included a little more information? That's all right. Usually these are fine. I mean, I printed out.
Right in there. See what you grab.
Yeah, if you want to. I've been working on with Randy to make sure we get the information as and when people are arrested. So if they're on Zoom. Have that. Stuff up there. Actually, there's one since then, but that's okay. This is good. This is use these. The other one had BOP and SSN. Since we're not letting them be public viewed, I thought we'd get that up front. So that's the only change. That's fine for now. All right, we ready?
Yeah, the record, but I don't know who this is.
You're Mr. Wright.
State versus right?
State versus Wright. We are on record in that case. It is case number 24 CR 207. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, Mr. Wright. Before you pay attention, we'll have you do that later. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Okay. Tell me your name.
He's right.
And I do have to have you fill that out, but I don't want you to be paying attention. I don't want you to pay attention while it's the record, but I need you to fill that out truthfully, neatly, so it's legible. That your name, address, phone number, and email. And if you don't have a phone number where you can leave a message, and both mailing address and physical address if they're different from each other. Will you do that? Okay, and your counsel?
Yes, I'm Denise Bonson. I'm here on behalf of Mr. Wright.
And for the state?
Yes, Your Honor, I'll go Meigs County Assistant Prosecuting Attorney here on Wilkins.
Thank you. We're here on a motion to revoke community control that was filed some time ago. And my understanding is that you've had time to meet with your attorney, although you were, I know, late this morning, but
I'm sorry about that.
okay, but you did get here and you've been drug screened and okay, so we're all good, ready to go on that. In that regard, has there been an agreement in Mr. Wright's case, or is this going to be contested?
Yes, Your Honor, it's the state's understanding that the defendant is going to admit the probation violation. And the state would recommend that the defendant have an additional special condition to his community control that he go to the STAR program and successfully complete that for the maximum amount of time.
180 days, that you said?
Yes.
And then at the completion of that, still be on community control or terminate?
Continue on community control.
Continue. All right. Anything to add to that, Ms. Bunce?
No, Your Honor.
All right, if you would inquire.
Yes. All right. Mr. Wright, you are on probation here in Meigs County, is that right? Okay. And part of the terms of your probation were specifically that you had to and it's part of your court orders that you were to, enter into and successfully complete any recommended treatment at Shawnee Counseling Center, is that right? Okay. And you, according to information that probation department has here, you left the facility against staff's advice on February 16th of this year. Does that sound right? And you were unsuccessfully discharged from that program. Okay. And so you recognize that being unsuccessfully discharged is not following the rules that were required of you to successfully complete the program? Okay, so you admit that you did violate the terms of your probation? Okay, thank you.
Yeah, you have to speak up. You did it. You do admit that you
Yeah.
violated terms and conditions. Okay, we'll find that the terms and conditions of community control were violated and the court is prepared to move on to the adjudication or sentencing or consequence phase. Is the state prepared to move to that?
Yes, sir.
Defense counsel?
Yes.
Mr. Wright, any reason why you believe we should not proceed to that part of the proceeding? Okay. The state have anything else to say regarding what they're requesting?
No, Your Honor.
Okay, how about defense counsel?
Yes, Your Honor. We would also ask the court to accept our agreement and to allow Mr. Wright to have continue on probation and to have the opportunity to go to the STAR program. I think that Mr. Wright is, it seems like maybe in a better frame of mind, I hope,
Yes.
to try to cooperate, do the things he's supposed to do than he was back in February when all these things went back. And I'm hopeful that with that in mind, that he will do better. I mean, obviously, STAR, unlike Shawnee Counseling Center, you can't just sign yourself out. You have to stay. And so I would just say that I'd like to have the court, allow him to do that and encourage him to try and do the things he's got to do to get through that program. I meet people all the time that successfully complete the program and think it's a wonderful thing. And it's, for some people, it's changed their life completely. I know they have special training and things that you can get at STAR. And so I would hope that Mr. Wright would avail himself of all the help that he can get there and that he would come out and have a better life and do the things he needs to do. And since he's going to be continuing on probation, that he would come and see his probation officer once he gets out within 2 days after he gets out. So the judge, of course, has the final say and she'll remind you of a lot of things. So these are just things that I'd like you to keep in mind, and everyone else as well.
Thank you. Mr. Wright, do you have anything to say on your own behalf or to present any information in mitigation of punishment? All right, the court has to re-review the purposes and principles of felony sentencing, and having done so and pursuant to the agreement, I'm going to find that a prison term is still not consistent with the purposes and principles of felony sentencing. Instead, I'm going to give a new condition of your community control that you must enter into and remain and successfully complete the STAR residential program for the maximum period of allowed, which I understand that period to be 180 days, and that you would continue on community control and have to report, as your attorney has already indicated, within 48 hours of your release from STAR to probation in person to get back on the schedule and hopefully have a smoother time finishing up your probation so you can have the rest of your sentence continue to be essentially suspended or held in reserve, so you won't have to go to prison. This is certainly what the goal would be here. Also, I need to tell you, because you're not going to prison on this particular violation, and it wasn't your first one, if I remember right, this is not your first PV. Yeah, so you'd be looking at going to prison next time. So if you go to prison, if you have another violation and you go to prison, you may be subject to up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive penalty. You also get credit for time served if you've served any time incarcerated since this motion to revoke community control was filed. You'll have to pay the court costs of the case. And you have the right to appeal this court's decision. Any appeal must be made within 30 days after your sentence, which is what we just did. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions? Or anything else from defense counsel on Mr. Wright's case? Do we have a bed date? We'll put.
Yeah, that's what I was gonna ask about.
His bed date is August 20th, 2026, so next Thursday.
So the request is that you go ahead and,
Yes, they would be taken into custody today, for the start bed date.
because they want you in jail, so yeah, you're gonna be remanded to custody, the Meigs County Sheriff. You will be sitting locally and getting credit for time served locally, until they pick you up next week. All right, any questions? Anything else from the state?
No.
All right, we'll go off record. We'll just have you have a seat over here, because we'll have to notify the sheriff's department that you've been, you're going into their custody. Yeah, go ahead. Yeah, you can fill that out now, if you would, that would be great.
Judge, I'm gonna take him back once I get the next one out.
Okay, yeah, we'll see who do you have ready next?
I think they're all.
Yeah.
Okay, great. So who was next on the list?
Seal is next.
Steele, okay.
No, calling her after her.
She's in jail.
She is young, so she is young, so that's the one.
Have you not talked to her yet?
No, 'cause she's in jail. And,
Well,
I think they're in Gallia, you said, so they might be bringing her in. I think the other, isn't there another person?
Oh,
think
okay.
we have to-
I thought maybe she was in
Is she in jail too?
I don't know.
If she's in jail too, they might have just thought to bring them all at the same time.
Oh, look,
yeah, but I understand what you're saying, that they're in jail, but you can, of course, would
I
be.
didn't know which jail she was in.
Well, we can always answer that. We have a spreadsheet access that the sheriff's office gives us access to.
Okay.
We can always tell you which jail.
Okay.
So anytime, so you
Yeah,
can,
that's what I need to maybe, or maybe have you guys send me a list or something, I don't know, that way I would know.
if you, well,
Yes, I can send out that live one. I don't know how to do that.
well, I don't know that they'll do that.
Oh,
Yeah, I think you're.
Well, I mean, I don't want something I'm not entitled to, but if I can get something like that.
Well, when you know you have hearings come up, if you
talk to
just,
The sheriff's department.
yeah,
The hard part-
Brandy or us,
Yes, Brandy is probably who I'd have to ask.
right? She would know which she is, because she
If
is
you
also
just
helping.
call over there, forget it.
Yeah, you need to ask Brandy or Bill, that would be able to, that would be good. All right, so who do you have ready?
Let's see,
Justin Carter was next on the list, Judge.
yes.
Carter?
Blankenship and Carter.
So you're ready on Carter or not?
Yes.
Yes.
Oh, hey, oh. Everything put in one phone.
What's going on with that door?
I don't know. It's been acting up the last few days.
Is it a new battery or something?
I think it's somehow how it's latching or not latching. We're gonna replace it with the same system we have now with that magnetic system. So I don't know when that's gonna be in, that, we have in chambers now, so I'll be able to I'll be able to look and see what it is and just release the magnet.
Oh, Nick has next door.
Exactly, like that, and like they have in, probate juvenile.
Okay,
Dated.
so does that mean we can go out like we do in mix? It just, we can't come back in unless you let us in?
I think it's both ways. So if you want to go out, you'll just have to tell me or, yeah.
Well, it's just like when you're not here and
Yeah,
stuff, so I was like. I guess
I'll have two.
He's remanded.
Yeah, I'll have two up here. One will say chambers and one will say jury or, so you can, they'll always be up here for you to grab if you need to. Yeah. And there'll be one on the.
Well, I'm just trying to think for practical purposes, how to get out
Yeah.
here.
You can always just get out that way, for
Right,
sure.
that's okay, it's just that's
Yeah.
saved me a few
Thank you.
steps, but, okay.
You could bring Mr. Carter in there.
He is, Judge.
Okay.
Yes. And that is.
Here, would you mind Cassidy, give this to Andrea as well. Thanks. Thanks.
Yours.
So Denise, I got to hold your grandbaby last weekend. Owen is a chunk. He's so cute. He was so good. He's just paying attention to everything. Huh?
Wants to eat, so.
Oh, he was good with me. He didn't fuck-
No, I mean, he acts like when you're eating, that he wants to eat what you're eating.
I'm sure.
I mean.
So how you know it?
So.
Yeah, yeah.
Show you when our kids were little, 4 months.
Yeah, yeah.
They can't stand that. So.
Yeah, they all three look like, so much like Roger. And Roger said, you said that Owen is built like Roger.
Yeah.
Just a,
Jules made like that as a baby.
yeah, cute.
Yeah, slimmer.
Like my mom. They were jumping on trampolines and having a big time.
Oh, I'm sure they had good times. Yes.
Like popular right there.
This one.
Mortified. State versus Carter.
We are on record in the Meigs County Common Pleas Court in State versus Carter, 25 CR 014. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, sir. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Okay, please state your name.
Joseph Neil Carter.
Joseph Dale Carter.
Neil.
Neil, thank you.
EAL.
Okay, and you've provided a written verification of your address, phone number, and email, is that correct?
Yes.
Okay, and the information on there is accurate? Okay, your attorney is going to identify herself.
Yes, I'm Denise Bunce. I'm here on behalf of Mr. Carter.
And for the state?
Yes, Your Honor, Abigail Wilkie, Meigs County Assistant Prosecuting Attorney here on behalf of this.
Okay, is there any individual victim in this case?
No, Your
By my motion to revoke. So there is a motion to revoke community control that was filed by the probation department, and you were arraigned on that some time ago. So we're here for the hearings on that today. Is there an agreement or is this a contested hearing? Agreement? Okay, so listen carefully. The agreement is going to explain to me and to you, and then you'll be asked some questions.
Yes, Your Honor, it's the state's understanding that the defendant would admit the probation violation. And in exchange for that admission, the state would recommend that he go to prison for 18 months and be unsuccessfully discharged from community control thereafter.
Okay, and with that then, Ms. Bunce, is there anything else to add to that?
No, Your Honor, that's not it.
All right, if you would inquire.
Yes, ma'am. So, Mr. Carter, you are on probation in Meigs County, right? Okay. And Your Honor, I can explain, Mr. Carter's hard to hear because he has cancer and it's metastasized to his throat, from what I understand. So he has trouble with his throat.
Yeah, okay, well, thank you. I know that your voice is very weak, so I'll try to ask again if I don't hear you clearly. So thank you for that. I'm sorry about the cancer.
So, Mr. Carter, you're on probation here in Meigs County, right? Okay, and you've been on probation since, I believe, last year, is that right? Okay, and part of the terms of your probation is that you're supposed to not use illegal substances, right? Okay, and so when you came in for your regularly scheduled visit with probation on July 9th of this year, you took a drug screen, is that right?
Yes, ma'am.
Okay, and when you took the drug screen, you ended up testing positive for marijuana, amphetamines, gabapentin, ecstasy, and methamphetamines. Now, you told me you have a prescription for gabapentin.
Yes, ma'am.
But you don't have a prescription for any of the rest. All right, and you recognize that those are illegal substances.
Yes, ma'am.
And you're not supposed to be using those when you're on probation. Okay, and you recognize, you and I talked about it, that that's a major violation.
Yes, ma'am.
Okay, now I know that you had some problems that you explained to me and you may or may not want to talk about that later on, but that is a situation that you cannot do those things while you're on probation. Okay, so because of that, do you recognize that you violated your probation by testing positive?
Yes, ma'am.
Okay, thank you.
We'll find that you violated the terms and the conditions of community control, and the court's prepared then to move to adjudication or the consequences stage. Is the state
Yes, Your Honor.
defense counsel?
Yes.
Mr. Carter, any reason why we shouldn't proceed to the consequences? The next hearing, any reason why we shouldn't come to the sentencing hearing?
Sentencing.
Yeah.
Because I lost my grandson. Because the way I was living overnight all that time, then my mother has gotten dementia to the point where she's forgetting everything. And they started giving her, my grandson's dad, weekend visits, which they wouldn't even let him, they wouldn't even consider him paying child support or nothing for the last 7 years. He ain't even seen my grandson in 5 years. So now he's getting weekend customer visitations. And when I got out, it must be a step I got into it because he thought I stole from him. I didn't. But my ex-girlfriend I was with, she moved out of the house. And so I moved out and I'm staying where I'm at 85 Chase Street. Anyway, I've learned now that, I mean, I didn't think it was that serious when I was going through until now I know. And it's not just because I had throat cancer, I also had colon cancer and now I get bladder cancer. And you could, like, I don't have the records to me to show that, but they cut the bladder cancer out and they said it's going to come back, but they don't know where. I don't have a whole lot of time left. So, but I do know that I can't go on the drugs. I just slipped up the one time. And once I did slip up, I just kept doing them every day after that until I couldn't see it. And I didn't realize at the time how serious I was slipping up. But I do have a full-time job out there, working for the same company for 20 years. And I do make good money. And I just, everything happened all at once. And I lost my grandson, I lost my girlfriend, I lost my parent, basically. I lost everything all at one time. And I don't drink. And that's, I just went to the next thing I did. But I realized that's wrong. And the girl that I'm seeing now, I thought she'd be here, but I don't know what happened, what happened. Her car broke down. She was driving my truck. So, I mean, the only thing I can say is I apologize to Mr. Wolf. I apologize for being, I didn't mean to lie to you. I just told you I should be clean because I didn't know how serious it did. So if I could have a second chance, I won't mess up again.
We're gonna move to letting the attorneys first talk about what their recommendations are, and then you'll be able to, I'll take this kind of as his allocution and his ability to make a statement. I'll give him an opportunity to make more statement after you two ladies talk if you want to. So the state's position.
Yes, Your Honor, the state would ask that the court sentence the defendant to 18 months in prison. The state's asking for this and has made an agreement with defense counsel for this, because defendant has completed treatment and has also completed the STAR program. So the state believes that 18 months prison would be an appropriate sentence.
All right, and defense counsel.
Yes, Your Honor. As the state has already indicated, we had an agreement, we have an agreement for Mr. Carter to do 18 months in prison and be released from or discharged from the probation department. Mr. Carter, as he said earlier, has had to go through a lot of different things, and I think he is just struggling, I think, to deal with everything that's going on in his life. There's a lot of things going wrong. And I think that he doesn't necessarily, I mean, I think he's competent, but I think he has some issues understanding the way this process works, and that's part of, I think, why he was saying some things before, because he wasn't sure necessarily when he was supposed to explain himself.
That's right. Not a problem.
So I think that's the reason, why he already has said some things. He's very, of course, disturbed because this is his life, and we're talking about, you know, going to prison, and that's not a thing most people wanna, say it's fine about or whatever, and, so he's struggling, and, I understand that his options are very limited, and so, you know, I try to help him to get the best outcome based on the circumstances, and he's indicated that he's in agreement with it, but I think he's just very upset about a lot of different things, and it's making it hard for him here today, but, I would ask the court to accept what we've agreed to do.
All right, Mr. Carter, do you have anything to say on your own behalf, or to present any information on mitigation and punishment beyond what you already said? I'm going to consider what you already said, but if you have additional, I felt like maybe we kind of cut you off because you were doing it somewhat out of order from what we typically do. So did you have anything else you wanted to add?
Just I can. 2 weeks for left to leave my parents home. If I can at least get another 2 weeks further to just get my grandson a little bit and get my affairs, legal affairs in order with like trucks and stuff. And what like for prison or whatever. But I would have, even if I had to get back on that, or I have to call on the phone, I would really eventually,
Do you have anything else you want to say?
once again, I didn't realize what the seriousness of what breaking the probation was doing.
Anything else?
Kind of just all it does to the courts.
All right, the court has to re-review the purposes and principles of felony sentencing, and of course includes the record. And there have been prior motions to revoke community control in which much less serious sanctions have been imposed, including inpatient treatment, and then with recurring problems, then the STAR program. So really the only thing left, as far as I'm concerned, is prison. You could be looking at up to 36 months. So 18 months is, half that, obviously. So I'm going to find that a prison term is consistent with the purposes and purposes and principles of felony sentencing, and impose what is only half of the reserve sentence. In other words, 18 months. And I need to tell you again, since you are going to prison, that you could be subject up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year and what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. There's no guarantee that will happen. It's discretionary whether you have PRC or post-release control, but I nevertheless have to advise you about that. You will be responsible for the court costs. You'll also get credit for time served since you were picked up this last time towards that 18 months. It picked up on this most recent motion to revoke community control, and you will not be released on any furlough. There have been so many other chances, and we've had those things really become a disaster, so I don't typically do those. And appreciate you asking for it, and I'm sorry you're going through so many things and had so many things happen, but the bottom line is that your consequences are going to be for a felony 3 where you could have been in prison for 3 years, that you'll get half that time, which is 18 months. And you have the right to appeal this court's decision, and the appeal must be made within 30 days after your sentence, which is what we just did. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of transcript, paid for from public funds. Anything else from the state
No, Your Honor.
or defense counsel?
No.
Okay, so you're remanded to the custody of the Meigs County Sheriff. You have questions? You act like you were gonna ask me something. You can ask. No. No, no, I do know what you're talking about. I do. And I would encourage you, once you're out of prison, if you're still having some struggles and you're, turning to, well, the only other thing, like you say, I mean, with this history with the, multiple OVIs with drug and alcohol use, with improper handling of a firearm and felonies, 3s and so on. It's not going to be easy for you to just come out of prison in 18 months and succeed. So I'm going to encourage you, although I can't order you to, because you're going to be off out of our jurisdiction once you've served the 18 months. In other words, the court won't have any authority over you at that time. But I'll encourage you to go to Warriors for Christ, and they would be more than happy to accept you out of the prison sentence to help you get reintegrated and give you some more tools to keep you avoid.
Well, I'll explain to you. He does like and want to go to Warriors for Christ,
Good.
and I'm glad
Yeah.
that what happened, what he's talking about specifically, and maybe what you say will have more weight than what I've had to say, because you're the judge. And that helps. That he doesn't understand why he and I've talked about jail time credit, that kind of stuff. And I've explained to him that Warriors for Christ, his time there does not count.
No.
But I think he wants to hear from you about that.
Okay, that is true. So you're asking about the time you spent at Warriors for Christ previously. Yeah, no, that doesn't count. That instead of going to jail or prison, we give everybody the opportunity, not everybody, but most people that have drug addiction issues, we give them an opportunity to do inpatient rather than sitting in jail for whatever sanction it would be, or rather than going to prison. The only time you get credit for time served would be like your STAR time would be against the 36 months. So you have 36 months plus some, I think, over your head. I didn't look if they were consecutive or concurrent, but I know you have at least 36 months you were looking at. So the credit, you get credit against that for the time you were at STAR, but you do not get it for inpatient care because you're not locked down. That's credit towards your 36 months. You still have to do a full 18 months now when you go to prison, though. So if you advise, if PRC wanted to send you back, if they came back and said, yes, that's my understanding of the agreement. Is that everybody's understanding what the agreement was, or was the intention? Yeah.
No,
Because you got 36 months potentially. So rather than just, the alternative, Mr. Carter, would be, I'm going to sentence you to the 36 months that's been reserved for you. And then I would have to, and would give you credit for the 180 days at STAR, but you would have more time than the 18 months hanging over your head. You understand what I'm saying? You would have to serve more than 18 months. You will get time, you'll get credit for your most recent regional jail time, since you were arrested on the probation violation here this summer. You'll get that credit. Is that before you went to STAR?
Yeah.
No, that's only counting towards the 36 months. So yeah, it's an 18-month sentence. Period. Now, if he's done more than another 18 months, but it doesn't sound like there's any way you did more than another 18 months.
166 days of STAR and then 40 days prior to STAR. So you're looking at a total of 1 or 2 of 6.
And so he would be looking another, it's going to be substantially less than your full sentence. So yeah, you could have a whole lot more time than that. This is a deal where you was worked out for you, where it's a lot less time than if I went ahead and did what probably most people think I should, and just go ahead and sentence you to your reserve sentence, 36 months, give you credit for STAR. If you want me to, is that what you're telling me you want me to? Because you're going to be longer than 18 months if I do that you'll be in prison.
It just seems like I'm going for here anyway.
No, you can do the math. So 100, what was it, 120 days?
166 days, he was a star.
Wait a second, let me get a calculator, I can show him. 166 days plus what?
He's saying 80 days. Supposed now. Right, so it still doesn't equal up to a year.
Yeah, that's, yeah. And it'd be a year and a half that he could have, you know, 2 18-month sentences he could, so it's still substantially less than 36 months total. So, and that's the order of the court, so I assume you don't want to have more time than what I gave you, but not for this most recent. You're only getting credit for the time you've been arrested since this most recent arrest for violation of community control towards the 18 months I just gave you. As I said, if I sentenced you to the whole 36 months that I reserved, then you would get credit for all the other stuff, but you would be serving more than 18 months because there's more than that left on your 36-month sentence, even with credit for STAR and the 80 days. So this is less time than you would be if I just said 36 months credit for all those other things. Because I am giving you credit for since you've been in jail since this most recent one. So, and again, you have the right to appeal this court's decision and that you must do that within 30 days though. So with that, then we'll be in recess ready for our next person. Who do we have other than Ms. Thiel? And you said you still need to talk to her.
Those, the Jerry Stone, Jason Langford.
Have you talked to Joseph Lee?
It's worked out.
Okay.
Stones is worked out.
Okay, is
Mr.
with
Blank-
Mr. Lee? You want Mr. Lee next?
That would work.
Yeah, Mr. Lee.
Mr. Blankenship's is partly resolved.
Partly?
Well, he's going to but argue what should be the sentence.
Okay, that's fine. No problem.
Judge, I believe that door is not locking.
Okay.
I don't think when it's shutting, I don't think it's getting lined up properly.
Yeah.
Something obviously going on with it.
It's like the lock part comes out before the door shuts. I don't know. It's just let it go to put that lock out, yeah.
So the meeting as it can't fully seat.
Oh, I talked, don't worry.
So on me next. Says. Go to your head.
State versus Lee.
We are on record in the Meigs Common Pleas Court, the State versus Lee, 23 CR 021. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Joseph Lee.
And you, did you write down your address, phone number, and email?
Yes.
Okay, and that information was accurate?
Yes.
Right, with that then, we will have your attorney identify herself
Yes, I'm Denise Bonds here on behalf of Mr. Lee.
and for the state,
Mr. Honor, Abigail Vilke makes the attorney here on behalf of the state.
and there's no individual victim in this case, I see. A motion to revoke community control was filed against you and we're scheduled for hearings on that today, and I understand maybe there's an agreement. Okay, listen carefully. The agreement is going to be explained on the record and then you'll be asked some questions. So what is the agreement?
Yes, Your Honor, it's the state's understanding that the defendant is going to admit the probation violation in exchange for a sentencing recommendation that the defendant serve 90 days of local incarceration and continue on community control thereafter.
And he was what with community control?
Continue.
Continue. Okay, and anything else?
That's accurate.
And then Vince, anything to add to that?
No, yeah.
All right, if you would inquire.
All right, so Mr. Lee, you are on probation here in Meigs County, is that right? Yes. All right, and as part of your probation, you were supposed to or not just part of your probation, but there was a court order because you had had a previous probation violation, you had to serve 30 days in jail, is that right?
Yes.
And once you did those 30 days, you had 48 hours to come in and see Mr. Wilford in the probation department, is that right?
Yes.
And according to their allegations in the affidavit by Mr. Wilford, he's saying that you would come in and see him, which would have, you were released from jail, it says on January 1st of this year, which meant you would have had to come and see him by January 3rd,
Yes.
and you did not do so.
No.
And you recognize that that is a violation of your probation.
Yes.
And so therefore you admit that you violated the terms and conditions of your probation.
Yes.
Okay, thank you.
So he went to jail as a result of the October 2025 motion to revoke community control and was scheduled to get out, if I understand correctly. Yeah, because he was here on December
Yeah, I
1st,
was
so he's
looking at that
supposed to
one.
get out January 1st. And when he didn't, when was he next seen? That was filed, that wasn't filed till February. Was he arrested at that time in February or not? Let me look here. He wasn't arrested till later, until this month. So there's no
That's fine.
contact between the January date and the arrest in June or July, in July.
I don't think so.
Just want to make sure I was reading things correctly. And this is the second community control violation. Okay, with that, then I'm gonna find that you violated the terms and conditions of community control and move on to the adjudication. Is the state prepared to do so?
Yes.
Defense counsel?
Yes.
Mr. Lee, any reason why we shouldn't move on to that?
No, no.
Okay, so state's position again?
Yes, Your Honor, the state would ask that the court sentence the defendant to 90 days of local incarceration and require him to continue on community control thereafter.
Okay, and defense counsel?
Yes, I also would ask the court to accept our agreement and to allow Mr. Lee to continue on his community control once he's completed the 90 days of local incarceration. Matter of fact, if the court does so, I know Mr. Lee has indicated to me that if he can get a copy of his entry, that would allow him to actually try and become a trustee at the jail. And he actually wants to do that. He wants to keep himself busy, and he's indicated if he gets a copy, then that will allow him to do so. Because sometimes it takes a while. He's asked me to send him a copy since I might get it to him quicker than he gets it sometimes from once it goes through the clerks and everybody. So I think he wants to try and change things and improve. I think he's unfortunately had some problems with that and is probably gonna have to pay for that. Obviously he is, but he at least is willing to admit when he's made a mistake. And I asked the court to allow him the opportunity to get a sanction and to continue with probation.
All right, Mr. Lee, do you have anything to say on your own behalf or to present any information in mitigation of punishment?
No, Your Honor.
Okay, tell me a little bit about issues in your life. Do you have some substance use disorder issues? Is that why you failed to appear between January and when you got picked up in July?
No, it's more transportation issues and housing.
So are you currently homeless?
No, I just was actually in the process of moving into a place here in Pomeroy when I got picked up.
Can you tell me a little more about why you didn't have any contact with probation between January and until you got picked up?
Just assumed that if I didn't have a address or, residence, that I might be violated for that, so I just assumed wrong.
Well, so you were avoiding because you thought there was a violation against you.
Yes.
One way or the other. You thought it was for a different reason, but you were intentionally avoiding rather than turning yourself in.
Yes.
Okay. All right, just because I'm thinking about this, I wanted the parties to have time to address it. Seems to me it would be much more productive for him to go to STAR and get some skills and be able to do things at STAR. Have you ever been to STAR?
No.
It just seems like rather than sitting in jail for 90 days, that would make a lot more sense. Does the state or defense want to address that issue?
could just have a brief moment, probation,
Okay,
before addressing the issue.
sure, yeah, that's just, to me, that's more productive time than sitting in jail, even if a trustee, huh? Yeah, I know, but we've sent them on, haven't we? I thought we sent them on technicals before, especially with priors, which is prison, we can't send them, yeah, on technicals.
Well, my question is, the F5 technicals max is 90 days
Yeah,
incarceration.
can't we
So
send him for 90 days down there? Will they not do 90
you wouldn't be
days?
able to get the skills that you're
Mm,
wanting.
mm. They would accept him for 90 days and could,
I would have to make a phone call to see that.
okay, if you want to do
That's
that,
my only dilemma with it.
Yeah.
I'm fine with Star, but I don't think that,
yeah, if we're limited it to 90 days of incarceration, yeah.
see
And
what I'm saying?
when did he get picked up?
What was your line?
So about a month ago?
July 14.
Yeah, that would make it even more
Maybe 60
complicated,
days.
yeah. Yeah, if you can find out though, and ask him if there's, because I just think that I
That's what
get
you're
more
saying.
than sitting in jail, at the jail. He's checking on that. Did, was there any productive conversation between the two of you?
Well.
Okay, that's fine, that's fine.
There's some things that are relevant, but not on record.
Okay, do you want to step in, we'll take a brief recess and step into chambers, maybe?
Yes.
Okay. Well, he's looking up what Star can and can't do. With a shorter term, well, we're coming in chambers, they want to talk to me about something else anyway.
I didn't look that far.
I just
I
saw
don't
this down if I didn't.
Hair up my nails on it over and I was like, what the heck? All right. There's.
All rise, please.
Thank you. Please be seated. You can go ahead and have a seat, guys. Put it back on before we can proceed.
Record on.
We are on record in the Meigs Common Pleas Court again. In the State versus Lee case, we did take a brief recess to have some discussions about the logistics of a technical violation and potential use of the STAR community based corrections facility. So does anybody else want to make any statements about my thoughts on STAR, which are obviously different than you had talked about in your negotiations? Anybody else want to say anything else about it?
The state would just leave it up to the discretion of the court, and believes that it would be an appropriate sentence if the court so chooses to impose that sentence.
Okay, thank you. And defense, if there anything else?
Well, I've spoken with Mr. Lee and I think he'd prefer not to go to STAR from what he's told me. I think he'd rather just stay in jail, but I understand the court, has to look at what they think is the best option under the circumstances. So, I mean, I'm sure whatever the court orders, he will accept it and do what he's supposed to. But like I say, that's his position, that he'd prefer not to go to STAR, but if he has to go, then he'll go and he'll do what he's gotta do.
Right. Knowing that that's one thing I wanted to at least talk to everyone about. Do you have anything else you want to say on their behalf or in mitigation of punishment?
Finding himself once back in the house and home and everything here. I mean, I just feel that if I go to STAR, I just set me back a little bit further because, I can't keep contact with my kids and my girlfriend and keep things moving forward like I've been trying to do so far.
We're talking about the same number of days, if that makes it any difference.
Right. I mean, yeah, but there's the contact is a lot harder from STAR.
How do you know?
My ex was in STAR as well.
Okay. But and the exes who you would be living with at the house?
No, no longer with.
Oh, okay. It's just that's your understanding from previous relationships.
Yes.
Okay. All right. Anything else? All right. The court must, as I said, revisit and review the purposes and principles of felony sentencing and the record, and continues to find that a prison term is not consistent with the purposes and principles of felony sentencing. Instead, you'll have a new condition of your community control that you must be goes and successfully complete 90 days at the STAR community-based corrections facility with credit for time served. So your actual days there will be more like 61 or 62, and they'll pick you up tomorrow from that facility. Also, if you've got, just beware that if there's some new charges in county court or coming to county court, if there's convictions out of that, you may be looking at another violation that could result in being at STAR for a longer term than that or going to prison. So it's really important that you know that that could potentially be coming. Also, if you would violate the terms and conditions of community control after you've served this time, you get in trouble again and do go to prison, you may have to serve up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of the supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You will have to pay the court costs in this case. You'll get credit for time served towards the 90 days since you've been arrested this most recent time. We understood that has been however many days, he said it was maybe 28 days or something, 28 days today. So you'll get credit for that. And you have the right to appeal this court's decision, and the appeal must be made within 30 days after your sentence, which is what we just did. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Also, you're going to continue on community control after your release, kind of like last time, but you failed to come back. I want to make it, excuse me, make sure you understand that you must come back to probation department in person within 48 hours of being released from STAR. And if you fail to do so, then there'll be a warrant for your arrest. And you do understand that because you're going to, you still have substantial prison time potentially hanging over your head.
Yes.
Okay, so make sure you completely understand that. Any questions? Oh, did you fill that form out before or not?
Yes, Your Honor.
Okay,
We'll just leave that person.
next person, that's fine, that's fine.
Okay.
Anything else from the state?
No, Your Honor.
Defense counsel?
No,
Sure. Okay, so, you'll be remanded to the custody of the Meigs County Sheriff, and be picked up by STAR tomorrow. Thank you. Anybody else ready? Excuse me.
Yes, Mr.
Yeah, I think they're not.
I'm sorry, who?
Mr. Stone's also ready.
One second.
Stone. You know, it's right here. I do need it. I just kept talking. Thank you.
Steele's name sounds like it should be on a romance novel or something.
Who?
Miss Steele.
Oh, yeah,
I guess that's
Danielle.
Danielle Steele, but Lincoln doesn't sound, that sounds kind of like a romantic person.
Yes, it does.
That attorney's name was, oh my gosh, I just had him, Brian Grimees out of Lawrence County.
Lawrence County.
He said that they do, a lot of domestic and civil stuff, but they've just now started doing criminal stuff.
And
But-
he can come up, but just couldn't be, or he can't come back at all.
Mm-mm,
Is
so
it-
we're gonna reschedule.
Oh.
But I wanted to let you know
But
that.
he's being incarcerated.
Yeah, I'm gonna tell Brandon.
Oh, yeah.
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 All right. And then, I'm gonna get plan all of that, I think, but now, oh my gosh.
I'm sorry, I'm still trying to find his case number.
25 CR 97.
2597, get it this way. There he is, okay. Right, I am ready now. We are on record in the Meigs County Common Pleas Court in State versus Stone. It is case number 25 CR 097. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, sir. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Gary Allen Stone Jr.
Okay, and you provided a written copy of your address, phone number, and email, is that correct?
Yes.
Is the information accurate on that?
Yes.
Okay, and your attorney's gonna identify herself
Yes, I'm Denise Bunce and I'm here on behalf of Mr. Stone.
on behalf of state.
Yes, Your Honor, Abigail Gilpin, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
And there would be a victim in this case. Was the victim notified?
Yes.
Is the victim present? Do you expect the victim to be present? I know this was scheduled a long time ago, so we're okay to go ahead and proceed then. Okay, Mr. Stone, you're here because a motion to revoke community control was filed against you, and today's the hearing on the motion, hearings on the motion. So with that, is there any sort of agreement, or is this contested hearing?
Yes, Your Honor, state believes that there's an agreement.
Okay, listen carefully, Mr. Stone. I'm gonna be told what the agreement is. You're gonna be told what the agreement is, and then after that, you'll be asked some questions to see if that in fact is your agreement, and then we'll proceed from there. So with that, go ahead. I was just pulling up his probation revocation motion, so I'll know what it's about.
Yes, Your Honor, the state believes that the defendant is going to admit the probation violation in exchange for a sentencing recommendation that he served 36 months in prison and be unsuccessfully discharged from probation thereafter.
Okay, and defense counsel. Is that your agreement?
That's our agreement.
Okay, if you would inquire.
Yes. All right, Mr. Stone, you are a probationer here in Meigs County, is that right? You're on probation through the Meigs County probation department.
Yes.
Okay. And you, as part of the court's orders for your probation, you were to successfully complete the STAR program, is that right? STAR Community Justice Program.
Yep.
All right, and you went to the STAR program on June 25th of this year, is that right?
Yes.
All right, and according to the information provided by the probation department, you signed yourself out or said you were not going to continue with the STAR program as of July 13th of this year, is that right?
Yes.
Okay, and you recognize that part of your probation terms were you were to successfully complete the program. Since you signed yourself out, that ended up being that you were considered to have unsuccessfully completed the program.
Yes.
Okay, and since you did not successfully complete it, that would be a violation of your probation. All right, and therefore you would admit that you did violate the terms and conditions of your probation by doing that.
Yes.
All right, thank you.
And based upon that testimony, we'll find that you did violate the terms and conditions of your community control and move on to the adjudication or sanctions. Is the state prepared to do so?
Yes, Your Honor.
Defense counsel,
Yes.
defendant prepared to go on. Okay, with that, then the state's position again.
Yes, Your Honor, the state would ask that the court sentence the defendant to 36 months in prison and unsuccessfully discharge him from probation now.
Right, defense counsel.
Your Honor, are you supposed to provide for the victim to say anything?
Oh, that's a good, thank you for that. Was there a big, thank you for reminding me. Do we do certainly at the initial sentencing, and I didn't ask that, so thank you for reminding me. Do we have any victim impact statement
We,
beyond anything that we might have had at the plea?
no.
Okay, thank you for reminding me.
Well, I just wanted to make sure we had everybody covered before
Good.
I said my spot.
That's fine. Thank
So-
you, thank you, thank you, thank you.
Excuse me. I mean, not that I want anything extra.
Well, it could be
added,
could be
but
helpful. We don't know.
That's right.
Yeah.
I don't know, and so I do want to follow the rules, so Your Honor, this is a difficult situation for Mr. Stone. This is essentially the maximum sentence that he could get for the third-degree felony, which was weapons under disability, and it's been very difficult, I think, for him to deal with, but he's been very, I guess you might want to say prosaic or just accepting, not necessarily happy about it, but willing to accept what his fate is, and he I think has some potential, and he seems like a pretty good guy, but I think there's just maybe been a lot going on with him, and like so many of the people that we see come in here, but he doesn't try to make us feel sorry for him or anything else. He's just trying to get through life, and so I'm hoping that once this is all done, that people will be able to, maybe get things straightened out. And I talked to him about the underlying charge. Of course, he'll have another felony here to deal with, but his other case was long ago in another state, and so we looked up like how to try and get that record sealed, and so he's gonna maybe work on.
Is it an
some
eligible offense in that state?
things. I don't know, I would have to look further, but it looks like the way they work on those things, which it was from North Dakota, they have it sounds like it's a similar statute to what ours is here in Ohio, and so I've encouraged him that once everything's all done, that once the time's passed, maybe he could look into trying to get that taken care of. And of course, this one here is at least as much as possible, if he can. And so that's something that I hope they'll be able to start over. And I think this whole business, from what he's told me, that this whole case started from some really stupid things as so often happens, and just blossomed and got beyond what he expected. So anyway, he's ready to accept what happens.
All right. With that then, if you would, do you have, Mr. Stone, anything you want to say on your own behalf or to present any information and mitigation of punishment?
No.
We'll find that you did, as I said, as found earlier, you violated the terms and conditions, which causes me to re-review the purposes and principles of felony sentencing. And given the serious nature of the charge and the underlying reserved sentence, I'll find that a prison term is now consistent with the purposes and principles of felony sentencing and sentence you to 36 months of incarceration with credit for time served. And that would include in the days you were at Star, would you get credit for that as well, and the local incarceration days as well. Because you are going to prison, I do need to advise you again, like I did at your other sentencing, that you may be subject up to 2 years of post-release control under revised code section 2967.28. If or when the period of post-release control is imposed following a release from prison, if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while in post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You will not be on community control after you've served your prison term. That'll satisfy your whole sentence. You do have the right to appeal this court's decision. Any appeal must be made within 30 days after your sentence. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions? I'll also order you to pay the court costs if I didn't say that, but we will make sure we get your credit for time served and the court cost assessed against you. Okay, anything from the state?
No, Your Honor.
All right, then you'll be remanded to the custody of Meigs County. Oh, yes.
Yeah,
Yes.
there's one other thing, and it's just, I guess, just, Mr. Stone's perspective. When he went to the STAR program, I think he thought that he was gonna be able to get substance abuse counseling there. He didn't feel that it was fulfilling his needs for substance abuse counseling. That was, I think, part of why he discharged himself. I just wanted to let the court know,
Yeah,
someone's perspective that had been there. And
yeah, I'm glad. How long were you there though?
10 to 12 days.
Yeah, so I don't know at what point they do more programming, but I'd say the programming doesn't get as active until you're acclimated and such, but I appreciate knowing that. And I would encourage you, like I have another person today, that if you have a substance use disorder, that don't just get out of prison and come back to the same environment, people, places and things. We would, even though you're not gonna be on probation anymore, we'd be more than happy to help you find a treatment facility that would best fit you. There are many in the region that are outpatient and inpatient, more intense, less intense, and that some are faith-based, some are not faith-based. So I know you won't be eligible in the men's system until you're almost released from there to do some of that programming either. Just know that the women usually have quicker programming for whatever reason. I don't know why, but I encourage you to try to find programming, even though you're going to be done with me, just because I don't want you to have to come back in on some new problems. So, but I appreciate the information too about STAR. All right, anything else we can do?
thank you.
Okay, you're remanded to custody. Thanks. You say you could even talk to Ms. Steele, or was there one other man that you had ready?
Mr. Blankenship, and we have, he's gonna do an admission and then he's going to argue the sentence. The violation.
So, are you gonna ask to do that argument today or to come back after some preparation time? Good luck, sir.
Well, I could.
Well, I mean, it's totally up to you guys. So.
Yeah, I could, because one of the alternatives he wanted was something where I could maybe get a letter of reason saying what he's saying he wants me to say from a facility.
Facility?
Yes.
Okay, well, you want to talk to him real quick about that? Because, we can bifurcate and have the
Right,
one
that's
hearing,
what I was
but
just
he
saying.
would continue, under the same, well, in fact, he would probably, no matter what, stay in jail. If once he if he admits. Catching up on the entries here that you've been working on the whole time. I had already signed those other ones that not realizing. So
Oh, that's okay. I think I just, so much is happening that I just,
it works better, I'm sure, if one of you is doing the questioning and somebody else is doing the. But the people like Mr. Bing and Mr. Starson, they got everything signed before they left, because I just signed Bing and. That's not what I'm kind of worried about. But he has private counsel and showed up voluntarily, so I think we just need to make a note. That if he's here next, if he hasn't, we want next time, make sure he does. A lot of these interests come through now. A bunch of them to review. There's a guy that has 3 or 4 cases, takes a while too here. Is she ready? Jim, is she ready?
I don't think where's she go?
I don't know either.
Oh, I see it.
The next one is Blankenship, you say?
Yeah.
I'm not seeing it. What's the case number?
240069.
069, thank you. There it is. Well, it's because it was one of the 9 o'clocks. Since it's going on one.
Yes.
No.
All right, are we ready?
Records on.
We are on record in the Meigs County Common Pleas Court in State versus Blankenship, 24 CR 069. For the record, I'm Linda Warner, the Common Pleas Court judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, please state your name,
Jason Blankenship.
And did you write down your address, phone number, and email on a piece of paper today and
I
turn
did.
that in? Okay, was that information accurate?
Yes, ma'am.
Okay, you can put your hand down. Your counsel is going to identify herself.
Yes, good
Afternoon.
morning, afternoon,
Good
whatever
afternoon.
time of day it is.
Yeah.
Good day. And,
day.
I'm Denise Bunce, here on behalf of Mr. Blankenship.
And for the state.
Yes, Your Honor, Abigail Gopi, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
All right, Mr. Blankenship, you're here because a motion to revoke community control has been filed against you. You understand that's what the purpose of today's hearings are. Okay, with that, then I understand that there's not really an agreement other than admitting that there was a violation and then leaving the sanctions up for argument. Is that correct?
Yes, that's correct. Yeah.
Okay, with that then, basically, if you want to just outline what you believe he'll admit to, and then we'll have testimony. And then we'll go. So if you want to just start with that.
Do you want me to go ahead and ask him?
If you want to, that might be easier. That'd be fine. Go ahead and do the testimony.
So, Mr. Blankenship, you are on probation here in Meigs County, right? And you've been on.
You have to do yes or no. You have to be your real words. Okay.
Sorry. There you go. All right, and being on probation requires you to do certain things and to go certain places, not go certain places, right? Oh, no.
Yes, ma'am.
Okay, I know it's hard.
It is very.
So part of what happened in your situation is you were supposed to go to the Riverside Recovery Services, is that right, or RRS?
Yes.
Okay, and so you were supposed to successfully complete that program, is that right?
Yes, I was.
As part of your probation?
Yeah, I didn't make it back with my mom car broke down.
Okay, so, but on February 12th of this year, Mr. Wilford, according to his statement, said that he had been contacted by the court liaison at RRS saying that you were unsuccessfully discharged because you did not return to the facility after receiving a pass to come to your home. Is that right?
Yes.
All right. And you recognize that that is a violation of your probation or community control?
Yes.
All right, and so you admit that you did violate the terms and conditions of your probation?
Yeah.
Okay, thank you.
Okay, we'll find that pursuant to your testimony, you did violate the terms and conditions of community control. The court is prepared to move on to the adjudication or sanctions. Is the state prepared?
Yes, Your Honor.
Is defense counsel prepared?
Yes.
Okay, I knew you talked about maybe potentially bifurcating. But you don't
Yes,
want to do-
Mr. Blankenship indicated to me, Your Honor, that he just wants to go forward.
Okay, that's fine then.
Have to
So-
take care of.
So with that, the state's position,
Yes, Your Honor, the state would ask that the court sentence the defendant to complete the STAR program for the maximum time, which would be 180 days. And thereafter unsuccessfully discharge him from probation. The state's asking for this because the defendant was, on November 25th, 2025, since 5 years community control with that special condition that he has an alcohol and drug assessment, completed and followed any recommendations. On February 18th, 2026 was the motion to revoke that we're here on today, which is admitted to have left treatment. That would typically be the probation department's first avenue for the probation violation. So the probation department is asking for STAR to be next rather than imposing a jail sentence. So that's why the state is asking that the defendant complete the STAR program and be unsuccessfully discharged.
right? And there's no individual victim in this case. So defense counsel,
Yes, sure. We've had a change of thought. And that is to say, Mr. Blankenship has decided that doesn't sound like a bad idea.
because you're going to be off community control when it's done.
Yes,
Okay.
exactly, Your Honor. And so and he's willing to do that. So,
All right.
sorry.
No,
sorry
it's
to tell
fine.
you.
That's fine.
That's something I just heard, so.
I understand. Mr. Blankenship, do you have anything to say on your own behalf or just accept any or to present any information in mitigation of punishment? Okay, the court's going to and has re-reviewed the purposes and principles of felony sentencing, and based upon the situation here finds that a prison term is currently not consistent with the purposes and principles of felony sentencing. Instead, you'll remain on community control through your new condition, which is that you must enter into and successfully complete 180 days at the Star Community-Based Corrections Facility. Upon successful completion of that, then you would be released from community control unsuccessfully, but you would not have to come back and be on community control. You'll get credit for time served while you've been since this most recent motion to revoke your community control. You also have to pay the court costs in this case, and I also need to tell you one more time that if you violate the terms and conditions, if you don't complete stars and do the whole 180 days, if you walk away, you violate so much they kick you out, or if you don't do what they tell you to do, you'll end up going to prison. If you go to prison, you'll be subject to up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You will have to pay the court costs in this case. You have the right to appeal this court's decision, and the appeal must be made within 30 days after you're sentenced. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions?
No.
All right, anything else from defense counsel?
I guess, Your Honor, I don't know if Mr. Wilford would happen to know, would it be around the 20th?
Or the bed date?
Or that date?
I don't know if he probably hasn't put in for it yet because
Yeah,
I know next week somebody's getting picked up on what day is it next week?
The 20th.
Yeah, that would be my
Possibly
estimate.
That would be likely, so it might be.
Next third.
The 20th.
Are you at regional jail?
Yes,
They have
ma'am.
certain days they pick up at different jails, and so that would be probably most likely, but wouldn't pick you up. All right, if no other questions, we'll go off record, and we'll be in recess. You still need to talk to Ms. Steele,
She's in there, yeah.
but you haven't
I
talked to her.
started to talk to her when we got called in. So,
Okay,
yeah.
all right. I'll step out and be ready as soon as you have the opportunity to talk to her.
Sorry.
You're fine. All right.
Oh, we have that one.
Be seated real quick. You can notify that you can't do it. You'll be there. I'll probably be back. You, okay. I found the sales. Yes, thank you. The lines were bad yesterday. With the stores. I didn't. It was bad. Thank you. Mama. You're not worried, so they can press you.
Or change the office.
Well, I just stopped by the office and said,
Is that lunch?
no one at the office. I tried. I was dropping off a USB to your staff for take some additional discovery. So,
Is there on?
they're free.
Oh, you do have.
Okay. Lindsay Lewis. Scott Kramer, which I filed a motion express on this morning. And Rachel Moore.
Talk to James on the news.
Yeah, my notes say I hate James Taylor. I'll show you.
I believe.
I'm glad to get off it. Which is funny because I normally do, it's like I normally don't.
Yeah.
So, the offer was 2 years. Okay, well, I'll double check it, but some years. That might
Do
be
you
right
want to-
because it's, yeah. Dirty room?
Yeah.
None of mine are in custody, I don't think,
It's allowed me.
unless they screw it. Very ridiculous oral arguments tomorrow. Juvenile case with the court says not to dismiss it on the pre-trial potential couple of years in show. And so the state appealed that. And I think that there are sometimes that shop we take flags and so often. This brief that I read from them is one of those.
Oh my.
Why like you guilty? So one of the issues that they raise is Marcy's law, saying that the trial court violated the victim's Marcy's laws, their rights. But the exact same prosecutor also said that they the victims were refusing to cooperate. Were refusing to come. Like, so it sounds like they exercised their rights. So I raised the standard, it's just that the state doesn't have standing unless they have authority. And it's clear that they don't have authority.
Yeah.
So,
Do you have oral arguments on that one?
so oral arguments on that. Like, what waste of time? Jeez.
Where's that at?
I don't know, Morris County. And I waived.
You wait.
I waived, but everyone else decided to go because there's two co-defendants. And I'm like, yeah, close down. So she's still kind of side. She gets here. I was in the seat.
He was here and I've already made myself comfortable with him.
Who's up next?
Denise said she's ready with steel.
She's actually ready.
She texted me.
Okay. And your first one is Lewis, will be Lewis at one. She's not feeling that. Wendy,
Yeah.
how you doing?
Good, how are you?
I'm great. We're gonna go. Oh.
Still texting her.
Us. Let's go, let's go to that. Back right up the office. I'm just gonna- Hey, look at that. You can sit over there, it's all right, but don't.
I already. I
Oh. Yeah.
Well, then it's not much. The distraction, she much more than stop. I got to go over and they. And that. This was an English. It's not. It's not going to take a seat there.
What angle that is? Don't like that angle. Like, I thought it was funny. What? I get how I heard. It's look bad, right? That's it. About what happens, what happens, or this comes to probation. Say what's to. Everything, including those TCC. Processing. And that since you.
All rise, please.
Thank you. Please be seated. Here you go. Come on up. Go. Place. I'm gonna minimize the screen. I don't know that we're gonna have anybody else on here that I know of. We'll find out about the one for the felonious assault guy that turned himself in later. That's Libby. I'm sorry. Does she bother you? I can have her. I'm sorry. I thought she came up to her place, but she's not being good. Libby. Place. I am ready whenever you are. We are on record in the Meigs County Common Pleas Court and State versus Steele 24 CR 201, not 021, 201 are the last 3 digits. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Lincoln still.
And did you provide your address and phone number and email on a piece of paper?
Yes.
Was that information accurate?
Yes.
And your attorney is going to identify herself.
And yes, I'm Denise Spence. I'm here on behalf of Ms. Steele.
And for the state?
Yes, Your Honor, I have a go Meigs County Assistant Prosecuting Attorney here on behalf of the state.
All right, and there's no individual victim in this case because it was a possession charge originally. We're here on a motion to revoke community control. Is there an agreement?
Yes, Your Honor, it's the state's understanding that the defendant would admit the probation violation in exchange for the state recommending that she go to the STAR program and successfully complete that as an additional special condition of her community control. And then upon successful completion, take on community control.
Okay, is that your understanding too, Ms. Spence?
Yes, it is, Your Honor.
Then if you would inquire.
Yes, ma'am. All right, so Ms. Steele, you are on probation right now, is that right?
Yes.
And that's through the Meigs County Probation Department. Yes. Okay. And part of the requirements that the Meigs County Probation Department had for you was that you were to go to the counseling center program, is that right? Yes. And it was an order of the court as well. And that was on February 23rd of this year, you were ordered to go to the counseling center. Yes. Okay. However, unfortunately, you, left the program on February 27th this year. And that you were considered to have unsuccessfully completed that program since they looked at it as a discharge, against their wishes or recommendations. Okay, and do you recognize that leaving the counseling center would be a violation of your probation terms? Yes. Okay, and so do you therefore admit that you did violate the terms and conditions of your probation? Yes. Thank you.
And with that, we'll find that you violated the terms and conditions of community control, and the court is prepared to move on to the adjudication or sanction phase as the state
Yes, Your Honor.
defense counsel.
Yes.
Ms. Steele, any reason why we shouldn't go ahead and proceed with consequences?
No.
Okay, with that, then the state again is asking for the STAR and continue on community control.
Yes, Your Honor, and I just wanted to make the court aware that there is a bed available at Star and it will be available on the 19th.
Okay, on the 19th. Okay. All right, thank you. And no individual impact statement, victim impact. So defense counsel.
Yes, Your Honor, I also would second that request to have Ms. Steele attend and complete the STAR program. She's interested in, you know, how it works, and I think she wants to try to get through things, and I told her that I've met several people who successfully completed the program, and I mean, it's gotta be better than going in jail, I would think, or prison, which is of course the other alternative. And that, you know, on the bright side too, she's in the Galley County Jail, which is not known for having a good place to eat. And so among the things that you can look forward to is I've not heard any bad problems with the meals at Star. So you get to wear street clothes, you get to eat real food, and I mean, there's lots of advantages, and she is planning to take advantage of those. So give her the chance is what I'm asking.
All right. Ms. Steele, do you have anything to say on your own behalf or any information to submit in mitigation of punishment?
No.
Okay, the court has to and has re-reviewed the purposes and principles of felony sentencing, and as after doing so finds that a prison term is still not consistent with the purposes and principles of felony sentencing. Instead, you'll have a new condition of your community control in addition to all those standard ones that you were told you had from the beginning of the sentence. And this new condition will be that you have to enter into and successfully complete the STAR Community-Based Corrections Facility Program, and that you would be picked up at the earliest convenience to STAR, which we understand is next week. What day?
A week from today.
A week from
The
today,
19th.
the 19th. So you'll remain in the custody of the Meigs County Sheriff until you're picked up by STAR. Also, you're going to remain on community control after you complete STARS. That's just a new condition of community control, which means that you need to come into probation within 48 hours of getting out of STAR in person to get back on the schedule. Because what happened to you between the time you left the counseling center and seeing me whenever you saw me last week or whenever it was?
I just.
So, okay, so that's obviously if that would happen, then you're looking at some more significant time. So got to make sure you understood that. You understand that?
She knew she was in trouble and she
Yeah.
was worried about it.
Yeah, okay. But hopefully you're going to successfully do STAR and then come in, just telling how many skills you obtained during your time there, and then start coming in regularly for your appointments. We'll also tell you though, if you violate the terms and conditions, like you don't complete STAR, then you're looking at going to prison. If you go to prison, then at a later point, you may be subject to up to 2 years of post-release control under revised code section 2967.28. If and when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. You also have to pay the court costs in this case, and you'll get credit for time served. You also have the right to appeal this court's decision, and the appeal must be made within 30 days after your sentence. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of a transcript, paid for from public funds. Do you have any questions?
No.
Okay, don't forget to come in as soon as you're going with Star, but you'll be remanded to the custody of Meigs County Sheriff and then picked up next week by Star. Good luck to you.
Yes.
All right, Denise, what do you still have here
Just have someone at 2:30.
at 2:30? So you got a break as opposed to Abby. Do you need a break? You sure?
Hopefully she'll have some.
No, I don't think, well, I don't know. Scott just got it, so we'll not get you.
Okay, thank you.
Uh-huh. Oh, yeah, you have PV Holly at 2:30.
It's Scott and Lewis, but
He has Lewis,
Lewis,
Creamer, and Morley. He has all those.
because what are we doing next week? Do we want to schedule it Tuesday or Wednesday? Or is that-
Oh, which one?
Lewis, gonna do a chief plea.
Oh, okay, I didn't know that. When is the, yeah, she came, popped back there. What'd you say?
It's so wrong with Paul.
What'd she do?
Jumped up in the chair and her
Oh.
leg went like this,
I don't know.
like it was hurting her.
Well, that's unusual. I don't know. Senna,
I
you're
was
okay?
worried about her.
Senna?
I think it was her right rear paw. She like
Okay.
held it up like this, like it was wrong.
I'll have to watch. Is she walking? Did she walk?
She's walking okay, but something, I don't know, something.
You know, it may have been that she was just getting ready to try to roll over and have you rub her belly and
Is that what it
realized she couldn't do that because there was a space.
But
Yeah.
I was like, she's not hurt.
I appreciate that, yeah. 'Cause, oh, me neither. Me neither.
Stand by.
Dog lover, you know, I can't help it.
I know, yeah, we're worried about them.
Yeah.
What's up, courthouse staff?
Oh, hey there.
According to little balloons.
Oh, yes, you got those. Just
Was reading
yeah, I
that.
have a few of those. Well, next week we have Lacey's case, so we're probably looking at the week after.
Right.
Maybe
Their
not-
trials are the 27th for the two that they want to take.
So I would think the 25th. At 11:30. Well, or maybe I'll,
Okay with that, because he's got our time.
right. Boy, that's gonna be tough. Or 3 o'clock. Let me see what's it. Probably 3 o'clock. We've got so many other things going on. I'd make it 2:30. If he's available, 2:30 on the 24th.
On the 24th,
Now, I know that you're gonna be dealing with Miss Brown too, which means we may have to go into 2 courtrooms and have 2 prosecutors, but if we're gonna get it in before the trial date, because then we have another jury trial that starts Tuesday that week. The Finley's on, says it's going. Yes, certainly.
All rise, please.
okay, Lewis, change of plea, August 24th at 2:30.
August 24th. Yeah, we do that.
Okay. And then you said,
We do that, August 24th at 2:30, we can do the same, we can deal with talking about. So you won't need to take that drug test today, but just know when you're talking on the 24th, there's a lot of times people come straight now. Around the road, we're sending you to the courthouse. Just know.
Yeah,
You want him on contract? He's fine. Inside.
I'll be hearing them.
Figure.
Read my message from Aaron.
We wanna go on the record for that date?
I don't think we need to.
Thank you. This should give it going.
We should just go on record for change of dates if the attorneys want it, otherwise we don't guess it.
Okay,
Usually
so
Brett likes to go on record, but
is it Kramer or Kramer? I don't know.
Scott Creamer.
Yeah.
He's out of custody. I'm waiting for him to show up. I filed the motion today though, and so we'll
you
probably,
go to rehab or something.
he's on paper out of Athens County.
Okay. We'll wait on that one then, Abby, because I don't know how long. Okay, like it'll take a hearing.
Like what time she's scheduling?
How long do we need for it? I don't know. It's just not a legal witness. It's just the opposite.
Maybe
How many questions are you guys gonna ask?
I don't.
I don't ask that many questions. I try not to. 2 hours, I think.
She got Kramer and Morley, right?
Yeah.
Rachel Morley.
Uh,
You have Rachel Morley to change of pleas.
yeah, that's mine. She's not here yet. It's a 2.
You're getting all the Athens County people that get busted down here.
Are they? What Creamer is Rachel Athens County?
And so ain't Derek Mays. I don't know if you have Derek or not.
I know the name. I have Adam Mays up in Athens right now. Oh, like they're related.
He's cursed. Back in the day, he was a mess cook. He's fat. Like if you're fat and
It's like being a skinny regular cook.
that would be me. If I turned to meth, I'd gain weight on it.
I mean, here's Athens watching this.
Now Rachel, when she was younger, she was beautiful.
Yeah.
You wouldn't know that look at her today, but there's a lot of miles and a lot of roads, but
She told her story. Wow. Ugh. Think about what stress and beer does to me. I can only imagine what meth and Fetty would do to somebody, you know? Tuesday night, you're eating Minnesota 5-2, and have a big win, 10-5 with Texas on Sunday. I don't know.
Correct.
I had a chance to get TV in summary of the Orioles season so far this season, so that it's not to change, and it's not here. So
I don't know who's coming back or not, he didn't say.
I got some really good props.
Well, he'll wipe that.
He said that's awful. I said it too.
Hey, Jim, you wouldn't know where an envelope is, would you?
Yes.
Can I phone one? Say borrow one, but then I'd probably never remember to return.
Can't really borrow it because you're not likely to return it.
Right, that's what I was thinking. So can I have one?
What size? It's like the big
Yeah.
vanilla one or mailing, but
Thanks, guys. Hey. When I tell you that, we're gonna try and make that right. The victim thinks that he's being done it. Oh,
the
so,
size.
yeah, that's good, and I never. Told people to call him back. Okay, okay, well, we're gonna go at 4.
I went ahead and sealed it for you.
Oh, thank you. You have to. Right. I thought we were so close. Oh, yeah, I'm sorry, I'm sorry. It's okay, I mean, we don't need it to certain, so we're certain. That's okay. Yeah. Yeah, all right. What? Not today, Tim, not today.
No, I don't know, you don't.
Today. Oh, okay, bye. Oh. Oh, you know why? I told you. Okay. Oh, I was pretty. I messaged you. Oh. You figured it out. You can have. I asked you about it, you said it's fine, but. You mean you got. The institution chunks. It is coming. But it looks like a little bit of that.
No, that's-
But
Sure. A daily crying.
except for the one for students, definitely made noticed.
Yeah. French, well, that's the suits and color, yeah. All was quite. Yeah, so this all that could be said. At least talk about space. She's a possibility. But even quickly personality features and solutions of the hospital. Great questions. The question is. This is the orders. Questions.
question anyway.
This is all understanding of the differences. Is that a state's expert that's saying that? No, she didn't have these first party issues? Cause I mean, I would think the entire defense is insane. What's the defense?
Yeah.
What? Cause I don't know, so what's the whole, what's he trying to get at? Like, he's leaving them up. Like, what's he trying to get at? She didn't do it?
They're not,
Oh, technically. That makes sense.
no,
I thought she
they're
was-
not mentioning it as a trial.
I thought you were right, that she was caught there.
But husband. But it's like, he's.
Isn't that a spy yet? What's his assessment? What's his strength? Some sort of spirit. You might want to listen to that. Do you know?
It was very,
This has come across like this.
because he claims that when he got to the scene, she was like, around, and he asked for his pistol, and she screamed, hair in the basement. I mean, and that's survived. They said she was. Yeah, she was only the moment. Couldn't speak. Animal consciousness. There's blood on the outside of the house, the window where she fell from, jumped from. And there's like.
Did she see this everyone?
No, hey, mom.
Same experience with things and I'm pushing the body would be.
She's just basically saying,
Coordination.
if you're saying that. She doesn't. She was on the bottom. Like 14 different medications.
You said the shepherd comes at this is the other one.
Like she even. Referred to it as.
But that also that doctor didn't seem like to kind of, it seemed to me like that's going to be trying to stop serious. First part of psychosis.
I didn't have a lot of time.
Yes, he was kind of like. You never, there's no such thing as postpartum psychosis in DSM. But yeah, there's, like, you know, where's the postpartum depression in DSM? She's like, what's the self-identified depression? He's like, well, it's not his own diagnosis. And it's like, you claim to be an expert on postpartum depression, but you was only going to practice like 2 months. You're like, argue about that. Because I was like really confused about it. There's so many things doing since really trying to do that.
Keep saying all of the stuff that I'm going to do for you. And we kind of walk over. It looks like, according to the evidence, where there was blood outside of the window and stuff, like she's forced out. Instead of jumping out head first. I think you might be weird.
She definitely just was. Hopefully that happened.
But then,
If you go up.
Anything on crime or just a dates? Just dates, you need to be on record for the others.
I don't think so. I can give them another.
She just wants to wait.
It's very straight.
You can come up if you want. Yep, start going up. I see there's going to get you some new dates.
I'm gonna write down on that. She doesn't just wait. So just wait and study. It's in that video of the car on 7-1 and flipped over by the winds. Have you seen that? Wow.
Brooke. Okay. The Creamer, we want a new date, so wanting a new jury trial date then too, I assume? Or do you want it before the jury trial date? It's like super soon jury trials.
We're vacating the church.
Okay, so how far out do you want before, you want, is it a motions hearing? that you
Motions
want?
hearing.
Okay, about like a month or less than that?
Yeah, a little over a month would be great.
Okay. What about? I would have September the 21st at 11:30.
I was just looking at that date. That'll work for me.
All right, September 21st. And is it like an hour? Or, well, actually, how long do you think you'll need?
No more than 2.
Okay, so that'll be fine. Okay, so 11:30. For the motion hearing. Jury trial.
Was it September 21st? So
Yes, at 11:30. And then what about October 27th for a jury trial?
that's fine.
Yeah.
But it's gonna be a placeholder, so.
Yeah.
Okay, so.
October 27th. Okay. Easy enough. The easiest thing I've done all day. Thank you, sir.
See then, make sure you do the crunch, okay, and think about what we talked about. And if you wanna call me or ask any questions about that. So. Thank you.
Hold up. I don't know why, she just said, don't let him leave yet. So I don't know. If maybe we'll have a conflict with one of the dates, I don't know.
Yeah. Well, I already put my calendar, so.
It's too late.
I already know card for them.
It's been filed, so you can go. She just wanted to make sure you had filed your motion to suppress, but I checked and you have filed it. So you're good to go.
Thank you.
I read somewhere, some that. Maybe you can find her DNA on those. They're nice hands, but it's nothing.
Yeah, but then. You expect. I feel like DNA in a case of like, anyway, because you're in a household with some parents and it's closed. I think you could probably twist that anyway. Well, DNA is not necessarily transferred, because when we're also like DNA on so they're gonna pull from specific spots. So it just means on that particular place where they sampled, there was nothing. So. And
Use for different. You know, or winning out there. when he got to the restaurant.
You guys just think that the guy did it because it's a guy. You don't wanna see the girl get in trouble.
No. This is old. This makes sense. Different shoes at the restaurant. Then
Why would you wear different shoes? What's the benefit of doing that?
I'm saying, why did he change the shoes?
So what? How's that a fact that demonstrates that he did anything wrong about it?
Why? Because I think that potentially his best friend went and posed as him. In one of the places.
That's the video, you know, with a straight face, with a straight face, with a straight face.
It was on trial.
Come on.
Anything is possible. Yes.
Go to the last murder I tried. My guy shot a guy point blank range in my alley. And they said not guilty on murder, but guilty on what they causing of that. Not guilty on the anger, on the intentionally causing of that, but he flooded this. I'm like, how? That makes no sense whatsoever.
It's sad.
Maybe
Did you
not,
talk to him?
but I know I had
You
one.
just meant to
I have-
enter him when he shot
I
you?
had a jersey right here. It was a giant bleeding heart liberal old lady. I could tell she did not want to put anyone in prison. And I think she was my holdout. I'm convinced that she's the reason. So I need. I want chaos back there. You guys want organization, leadership, no. I was in law school still. Next day, I used her. Where my guy was. Racing in his house. This Mexican thing was living there. This 13-year-old kid was staying there with his younger siblings. His uncles and his parents were gone to work during the day. So I got racing in the house, steals the kid's bike. I was walking through the house. My little kid goes upstairs, calls 911, hides in the closet, decides to get a camera and confront my guy in the house. This is all on 911 recording too, by the way. So my guy takes his camera out of his and pushes him down. He brings on 911 and walks out the back door to the waiting arms of kids that are standing there waiting for him. So that's on body camera. Him walking out of the house with the bike is on body camera. So we go to trial. It was terrible. And so I was secretary of that when guy was looking for me. What are we doing here? I'm like, what's our defense? He's like, we're looking for a kook in the jury. He's like, we want a kook. Someone who's just crazy. So just partway into the state's selection, he leans over me. He was like, back, whatever. He's like, that's our kook. She was batshit crazy. But she was from Colorado. She moved, but she had really strong opinions. But then we found out she was from Colorado originally. She met this guy and became pen pals with him, and then moved to Ohio for him. And subsequently they broke up. And we explored a little bit more. And it turns out he was in prison. That's how she became pen pals with him. And he was in prison on a third charge. So she hated people who were accused of getting fat because of that guy. So we're like, that was her. She was kooky for sure. She was kooky the opposite way. So the kid is the first person to testify. And he testifies and does a great job. And they play the 911, they play the fucking body camera. So I get up to cross-examine this kid and I look over and there's two jurors in tears that would be crying listening to this kid's testimony. I was like, fuck. I'm like, I'm so fucked right now. The best part was the guy refused to come out of his cell for the trial. And so he had to be in a basement cell for the Zoom. And I had to go down the basement, ask him if he was ready, in between witnesses. It was terrible.
I'll put you an address on.
Okay.
And first is a change of plea, right? Mm-hmm. So the judge will want a drug screen definition.
No.
Did you just go to the bathroom
I
as a
did.
little kid? You just did?
Yeah.
Alright. Well, let's go, we'll go talk, we'll go do some paperwork. The prosecutor, was, I want 100 packs. When you put that kiss on this thing, I want one of this week, so I'll do it like five. It's like, well, 6 now. I was just like, I lost my father. Since 2005. It's my kid. So it's all- Okay.
I figured. Yeah.
I was like a little band-aid where you would give an ID, such as a cost last night, to get it on. It's just a problem. It's just this. If she went to the emergency, I'm just gonna ask them about it. But respond to the case. She's at least filling out the contact information paperwork, I've gone over all the police stuff, so you're releasing that. You go first, I want to make shots.
All right.
I mean, you have to tell, but I can't go past that day. But anyway, she's live, but she only goes like 10 to. They all the same place, but he goes like. I don't see it. She has a rate, she's moving today, but it's like a vision. Right, oh, yeah. And it's gold and it has like a flower of diamonds and it spins. So I'm like, that would. I'll just say what's up. Oh, yeah.
You come out.
Yeah, just want to back out that.
4 and 5, the media suppliers.
It'll open, it's gonna turn. Back, it's well.
Are you here for a hearing?
I'm here for 100 Brown
Okay.
3 o'clock, so I'm a little early, I made it up here, but.
And so I wondered if that was you. He's back in our law library, so I can take you back there if you wanna go ahead and speak to him.
Great.
Go up around this way and just follow me if you want.
Yes. Have you seen him yet? He's not there. He's next door. I spoke with him yesterday, so I'm okay. I don't necessarily. Sit down with him. Right. I'll have to bring him over. Okay. Thank you.
I've been in the journal. I'm getting it to where I'm mostly staying. I thought that about my exit. Yeah, we're too young to have, who had a judgment. He was made of very difficult. I'll try to be. Right. Oh. Okay, nice to meet you.
won't have much fun.
Tell them about the jury room.
What's that?
Might tell them about the jury room, if that's okay with you.
Yeah, you want me to come in there? That's open right now, like what's out, so yeah, we spoke yesterday, so I don't think this week or the week. We'll see. Even though I see. This is what this is like. Outside of. I'm like, I'm not talking. This is about the city. So I don't find that. How long ago? That's not bad. It was taking. Oh, it's not bad. It's not having. In the phones, people went down, so. They were fortunate when there was other people down slowly coming the other way, so. We're all places that get around and. What's going up and. Maybe, in time, I don't know, I think it's at 3 o'clock now, so we got a few minutes. Speak right and I'll speak to the mom once, we've got me arrangement, and I've been in contact with her all day so far. I'm just saying.
Yeah, this like old building is, yeah, pretty Civil War, I believe, as part of the houses. And starting floors are not made that way. It's just a lot going on here, and they made the best of what they have, I guess. It looks very useful. That's not the best.
I don't know, the courthouses.
This one does, and ones that I've been in are very interesting. Courthouse, and I remember, and that's one I like. It's a beautiful one to have like in the middle, it's more like it's like helping.
You're very right. So they built the original house. And the new so they only, so we went and they. This time you connect them, I mean, almost like a breezeway from the home or something. So once you get up there, so yeah.
Yes, I had a couple of hearings.
You know what did that? We're not like sure, we're not the 18th.
I can't recall if that might be. At the time I went, they still had a, like a cafeteria. Trying to think what were that before. It's not so good.
It was there when I, retired, right, when I went to law school, but I've been back after law school, it had already gone out. Now it's just open space, over everything was talking about was the office space behind. Question for us, 6 times.
Yeah, that was, I had a client that I've done work around here, and he ended up having the attorney at the beach. So she's, unfortunately, once found, of course, there's no real easy way to do it from here to there. So.
Down 7, pretty much.
Yeah.
Or I guess technically probably going across the Jackson and down
Well,
3, that's probably worse.
Well,
You would. Yeah. No, on these, yeah, it's something.
So, yeah. I mean, matter of fact, what's weird is how it goes.
I have fun sometimes before. No. 2 a month.
Jack loves it. Can't do anything.
Everyone's kind of. Do you need a message or do you actually understand this? You like? You don't do it? Really? Not as much as you want. You don't do it? Yeah. You want to. I tell you what. I was in mine. I was living in five. And so you need to bear in mind. He's not looked. He's all in there and. I apologize, you know, the whole thing that he's saying. So we're still in the whole way. Isn't that good? And then I thought, all things that you made on really about this one, if they're talking about.
Well, I've had my 7 years. And she's even done.
You see what they're.
That we've done all sorts of.
That was our last slide.
Well, it's understandable. But I just think you're still, but I like it.
Is that why you said that? I need to change your underwear.
Well, I think you, I'm really bummed here out there. I'm sorry. Oh, no, I agree, yeah. Well, a lot of girls, you know, a lot of girls.
Okay. A little break. Yeah, PT test for us, but PT stands.
I thought about that.
This is why he's a medical.
Yes.
He talks old and make up. Talks old.
Yeah, I mean, you talk like, I think,
You good enough on it.
Yeah, I know, you don't really, I don't. Yeah.
Now, the one thing that does it, get it, I don't know what the product is. That's stuff. No, you see, there's something I said.
My first love. Yeah, let me grab her first.
I was those people, yeah, those situation, I don't have. You know, it says I was trying to help
Yeah. I think so. I say three. All rise, please.
Thank you. Please be seated. Libby, you can say hello and then come on. Yeah, you're new here. That's Libby. Liberty, her name. She works here.
She works there.
There's another one too.
Oh.
She's a working girl. That's what I'd say. She's a working girl.
Oh.
Yeah, I think we're gonna take care of her first. That was supposed to have the plea.
Okay.
Morley, right? Her name. Libby, say hi and then come to your place. Libby, place. Good girl, come on, place.
State versus Morley.
We are on record in the Meigs Common Pleas Court and State versus Morley 26 CR 037. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Correct.
Tell me your name.
Rachel Morley.
Okay, and you're gonna fill out paperwork and you're still gonna be under oath. Oh, you've done it already?
Yes.
Is the information on there accurate?
Yes.
Is it legible? guys?
Yes.
Okay, and you have a duty to inform if that you change any of those, and inform the court and the clerk of courts in writing if that information changes. And your counsel,
Scott Petroff.
okay, and for the state,
Yes, Your Honor, I would go to the Meigs County Assistant Prosecuting Attorney here on behalf of the city.
and there's no individual victim, or there is an individual victim is, okay, is the victim present? Was the victim notified?
Yes.
Okay, we were scheduled for a change of plea. However, my understanding is that you've not yet had urine screen, but the indication is that you would not be able to do your plea today because of what might show up, correct? Based upon that, then typically you're gonna either be going in custody or directly into an inpatient facility while we work towards helping you get whatever help you need to be completely sober when we do get to the point of a change of plea, because we can't do it if you're under the influence of any illegal substances. So with that, my understanding is that you have a place in Athens County and it's called,
The Carlson Center?
okay, have you ever been there?
No,
And it's near Oblenis,
correct.
and how did you get connected with them?
I actually used to work there and a couple years ago, and my ex-mother-in-law is a case.
And who is going to come get you?
The Sheila,
Who's she?
my ex-mother-in-law, the case aide. I mean,
She is an employee.
yeah, she is an employee at that rehab. She works there.
That's a little too. I mean, I need something from them that you would.
She is, like, she has her.
Let me finish what I was gonna say. Her working there is not enough. But that close relationship makes me concerned that that might not be appropriate placement for you. But I'd want to make sure that we had something in writing from them that you would be going directly to inpatient care. I mean, if some other while she might just take you home, and I can't have that happen today. So you know, we would need that business, someone other than your ex-mother-in-law, to communicate with my probation department that legitimately you would be housed there tonight and you would stay there until further order of the court, that this is not just your mother-in-law's doing you a favor. It would be much better, I'd say, to just pick another place, and it can be, that doesn't sound like a good plan. Oh, yeah, I've got several messages that, you know, yeah, but that's not gonna be a good thing.
The Carlson side.
Right, and in particular, the connection to, your mother-in-law is Miss Perry,
Yes.
yeah, so no. That was the.
So the court would request that we find a different treatment center, is that? We have a
Yes.
few moments off the record.
Certainly, yes, I know that one is available, we haven't really checked others because time is of the essence. No, we're not gonna put your rural women's is, they get you in, they get you out, they don't have any aftercare. That's not been a good thing for situations. By the time you're in the felony world and you have these issues, that rural women's not gonna do it. And you need to get away from your people cases and things, which if you're in Athens County, you need to go. You need to talk to your attorney. We can go ahead and do the arraignment. Are you Mr. Cremines? Yeah, come on up. What is his client's case number?
I honestly don't know, because I haven't even looked it up yet. Let me look that.
Thank you, Your Honor, for accommodating my schedule. Well, I don't normally ask to zoom in, but they said I was told 1 o'clock and I was already, I think, like around 12.
Well, yeah, today's great schedule's so crazy. I didn't think we'd fit him in at all, but we've got some other bumps in the road, as you can see. So go.
I appreciate it.
Good, yeah, thank you. Go ahead and have a seat, both of you. What's your, it's Cremines, is it?
Yes, Your Honor.
Okay, what's your first name?
Brian.
Brian or
Yeah.
what?
Brian would be
Okay, but what's your client's name?
Hunter Brown.
It's case number 26CR104.
614. There it is, okay. All right, we'll put all this on the record. I know you introduced yourself and I appreciate that, but we're gonna have to do it once the record's on again.
State versus Brown.
We are on record in the Meigs County Common Pleas Court in State versus Brown, case number 26 CR 104. For the record, I'm going to warn the Common Pleas Court judge, please raise your right hand, Mr. Brown. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
State your name.
Hunter Thomas Lee Brown.
So 2 middle names?
Yeah.
Hunter Thomas Lee Brown. Okay, and if you haven't, you need to fill out paperwork with your name, address, mailing address, physical address, phone number, email, and so on. Have you done that yet? Okay, so I assume we have that and it's legible.
Yes.
Okay, and your counsel for the record is going to identify himself.
Brian Means from Cal Fisher and Means, bar number 0093097.
Thank you. And you're making a notice of appearance at this point in the case. And for the state?
Yes, Your Honor, Abigail Gilkey, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
And given the nature of the allegations, that there would be a victim or victims, is that correct?
Yes, Your Honor.
Was the victim notified?
Yes.
Is the victim present? Did you anticipate the victim would be present? Okay. With that, then I'm prepared to do an arraignment on the indictment. I don't know if he got served with the indictment yet. He certainly has by now, but I know whether it was more than 24 hours ago, if he wants me to read the indictment and go through the potential penalties, or if you want to waive the same.
We waive, Your Honor.
Okay, you would have waived the 24-hour rule in case he hasn't had it personally served in within more than 24 hours.
Still waive.
Okay, and what about the reading of the indictment
Waive reading.
and explanation of penalties and rights?
Still waive.
Okay, you agree with that, sir? For waiving all those things. So with that, we'll move on to the issue of bond. What's the state's position on bond in this matter?
Yes, Your Honor, the state passing that bond, we set at $100,000 with 10% permitted. The defendant is to have been alleged to be part of an organized group of 8 individuals who plotted to assault the victim and coordinated with each other to restrain the liberty by blocking him at the Marathon gas station in Pomeroy, where multiple people, including the defendant, assaulted the victim and caused multiple facial fractures. Once the victim was able to get away, the defendant and others followed him to Mason, West Virginia, where the encounter continued. This is a very serious matter, and the defendant is just as culpable as co-defendants Mark and Kristen Daly, who were given a $100,000 bond with 10% permitted. So the state is asking that the court would set the bond the same as the other co-defendants.
All right, and Mr. Green, you want to make a statement about bond?
Thank you, Your Honor. Your Honor, we don't have an objection to the $100,000 bond with 10%. My client has a bond that my client is prepared to make today. One thing that I would ask, Your Honor, is my client does work, and as you're aware, is innocent until proven guilty in this matter. He works 7 days on and 7 days off with a company called ACNR out of Pennsylvania. I believe you do work on the boats. And so he is scheduled to go back to work on August 25th. And then it's 7 days on, 7 days off from there.
So why is the off name? Is this the off 7 days?
He'll be off
Off
7
the day,
days,
okay.
and he turned himself in this morning. He
Yeah.
got back last night, turned himself in this morning. You're hopeful that 2 weeks this time?
This is 2 weeks this time.
Okay.
Okay, sometimes it is 2 weeks and some.
No, I just switched. I was going for 2 weeks, but I switched to a week now, so they put me home for 2 weeks.
But you are from now on gonna be week to week to week to week, okay?
Okay, that makes sense, because it looks like August 25th is when he goes back, so that'll be 2 weeks and then. But we could potentially work around that schedule or. at least-
Yeah, we need you to look at yours and be prepared to work around that, so we'll certainly do the best we can to work around it. I will order the bond to be $100,000 with 10% cash permitted, plus the GPS monitoring system. We use a repath monitoring system where you have to keep your smartphone with you with an app where you from time to time have to check in that you're actually with your phone. It'll monitor where you're at. It will do some other tests through time. You know, you have to keep it with you. Do you have that phone available today to be to use?
It's not with me.
Okay, how can we get it to you?
Need my phone?
You could get it signed within the day.
Well, like right away. You come right back? Yeah, yeah, you better, because we gotta do it before 4.
Okay.
So, yeah. Yeah, and it's that's an additional $250.
Okay, so I already got 10,000, so I need 200.
50, yeah, and that's $250 per month, yeah, so. $250 per month, first month payable up front. So that'll be bond. Conditions bond are that you cannot use drugs, alcohol, or other mind altering substances. You'll be subject to and receiving random drug screens. You are firearms disqualified. You cannot own, possess, acquire, use, or attempt to do any of those things with firearms. And you can't get any other trouble, no contact with law enforcement resulting in charges or arrest. And any such contact must be, if it has happened, it must be reported to the court immediately. And no contact with, what's the name?
David Darsh.
David Darst. Do you have a question, ma'am?
Where's his phone?
Where is the phone in the house?
I think on top of it.
So do you understand the no contact directly or indirectly with David Darst, the victim in this case? You understand that? All right, any other conditions of bond that the state's requesting?
No, Your Honor.
Okay, next we'll look at those calendars so we can try to figure out a scheduling orders that it'll minimize your interference with work.
Okay, so he's off right now for 2 weeks.
It goes back to the 28th.
Alright, so then off for 2
You have
weeks.
one.
For 2 weeks. Off, okay, so are you off the week of September 21st then?
Saying it's back 25th.
Oh, it goes back to 25th?
August 25th, he goes back, so you said September 21st.
Yeah,
You're having to calculate that out, so it's.
do you have anything on the 23rd?
So you're going back to work on a Tuesday? Okay, that does make it a little more complicated, just to look visually. So 25th. September.
Pardon, did you say?
I was asking about September 23rd.
It's gonna be back on, it looks
Oh,
like.
he'll be back.
Well, look, so 25th through September 1st, he's working and he's off September 1st till the 7th. And he's on the 8th to the 14th. He's off the 15th to the 21st. And
2 weeks.
no, he was, but now he's gonna be week to week. That's what he was.
Oh, okay.
So, yeah,
I had it backwards.
I
Okay.
was gonna say, I'm in a trial with 23rd and 24th.
well, but he's, according to this, yeah. Basically, do you need a calendar? Do you have a, okay, you've got one that you can look at. So you'll have to do the counting to make sure it's right. Do you have a calendar, young man, that you would be able to look at? Or it's on your phone, you know, of course, of course.
What about, so will you be home on the 30th, September 30th?
Well, yes. What time do you think?
We are available anytime 11 to 3:30 or 3.
11 would be perfect.
Okay, so
I've got hearing in Guy County the afternoon, and so that would make perfect sense.
all right, September 30th at 11 for the initial pretrial.
Keep counting weeks, 'cause I'm not.
All right, so that home, so that'll be working. Oh, okay. What about October 28th?
I'm free all day, nothing on the calendar, unbelievably.
Right. And does that work out for you that that's a week you're off?
Okay, so October 28th at 11 again. And then a jury trial date of. What about November 24th?
I cannot do the 24th. I sit as acting judge at our municipal court, and I'm been judicially decreed that our judge is out on Tuesdays. And so I have civil docket in the morning and the traffic court again.
So that day doesn't work at all.
And is that every Tuesday then?
Every Tuesday.
Okay.
Oh, every Tuesday, so we'd have to start it. How many days would well, this trial might take a while. So,
Now, most of November, at least, and I don't know what days court typically does the trials.
we usually start them on Tuesdays and go through the rest of the week, but if we know it's gonna be longer, we will start them sometimes on a Monday.
Well, if need be, I could potentially, see if I could get the judge to cover one day for.
Okay. So look at his calendar and then know you may have to impose on the judge for that,
Oh,
assuming it goes to trial, because, you know, by then it may change, so let's just get a date just in case.
you wanna bump it up a week to the 17th?
I'm free the 20th.
Okay, let's just do
Yeah,
the
if he's
24th.
actually,
Oh.
if we could do the 17th, that's better, because I'm only asking him to cover the one docket.
Okay, let's do November 17th at 8 AM for the trial.
Yeah, all of our trials start at 8 AM. Also, there'll be an order that you have to be fingerprinted and photographed today, and DNA taken and stuff before you leave if they haven't already done that. Did they book you?
I haven't done nothing yet.
Okay. So officer, he'll have to have his photograph and fingerprints and DNA collected today before he leaves. Anything else from the state that you want to accomplish today?
No, Your Honor.
So obviously you're in custody until or unless that bond money's paid and your repath's paid and you got the phone to have the repath set up. So anything else from defense counsel?
No, Your Honor, thank
Do you have any questions, Mr. Brown?
I'm in.
Okay, then we will see you September 30th. Make sure you get all hooked up with the probation department for the repath, and they'll have you coming in from time to time when you're off to be drug screened. All right, good.
Should be, she's been out with all. We do have this. If you guys wanna do that, I'll when I do this bond, and then let me know.
All right, Mr. Petroff, you ready to come back up? Thank you. Nice meeting you.
Thank you, Your Honor.
All right, we're back on record, are we?
Yeah.
On State versus Morley, 26 CR 037. And hopefully I made it clear, and we're not going to have any pushback that the circumstances of her having worked there and your mother-in-law, that's not happening today. So we can look at a number of other places and it may not be able to get you today to them or not. We'll just see, which places you're interested and willing, and then the probation department will try to hook up with one and see what we can do. So
We spoke with probation, we agreed Field of Hope is on their way.
okay, so I'm gonna change your bond to an OR with a special condition that you'll have to sign off on, that you go to directly from here to the Field of Hope and remain there until further order of the court. If you would leave or not be in compliance and working that program, there would be a warrant for your arrest. And we're gonna go ahead and reschedule. So that's a condition of bond, just like a condition is not use drugs or alcohol, which would have been why we were arresting you today. You understand that? Okay. So you have to stay where you go unless or until, if you need to switch, if you find that's not a good fit, you don't just leave. You talk to your attorney and make some application, and we see where else we could maybe put you. So the alternative is sitting in jail. So I assume that's why you made this selection, and I understand that. The other conditions of bond are going to be like you already had, that you can't use drugs, alcohol, or other mind-altering substances. You'll be subject to random drug screens. Your firearms disqualified. Was there no contact with the victim on this one? And no contact with Michael Douglas, directly or indirectly. So no contact is a condition of the bond, even with the new conditions. Any other conditions of bond that we want to put on her? The state's asking for. Okay, and any questions about the bond and the conditions bond?
No, I do have, a couple questions. So I do have a mass on my left lower lung. I go to the doctor for that on the 3rd, September 3rd.
November 3rd?
September.
September 3rd. Well, that's a Saturday.
Or September, I don't.
Well, they will work with you, but I have to have verification. And where is that appointment?
In Marietta.
Okay, they'll work with you. We'll talk to them when you're intake about that, because we want to make sure you're following up with what you ever need to for medical purposes, and they'll want to help with that. They work with a lot of people that have medical appointments. That shouldn't be a big deal. What was your other question?
I don't.
You what?
I don't know. I don't know.
Okay. Do you understand what's going on here?
I do.
Okay. Just the attitude doesn't seem like, that the alternative's jail, so.
I understand that, but like, I was honest and.
That's good, and that's why we're trying to get you someplace other than jail. That's a first step. It's first step, and that's great, that you're honest, and I appreciate that, but that doesn't give you a go get high again card. So that's why we want you to help you and, appreciate the honesty to try to get you the help you need. With that, then we need a due date and probably need to give her a little bit of time to get oriented and probably get past the medical appointment, so we know what's going on with her medically.
What about September 22nd at 9:15? I already have it here at 9 and 10.
And we're still good. The state's not gonna try to change the plea at this point, at least. With whatever the agreement was. Sometimes when.
What date was that?
9/22 at 9:15.
Yeah,
You're already here, a couple, unless that's an issue. I think that, if it's Field of Hope that's coming, they should be here within less than half an hour, and you're gonna have to sign some documents, so I'm gonna go ahead and get those, electronically signed so that the clerk can get those prepared for you. Right, anything else from Defense Council? Anything else from the state?
No, Your Honor, thank you.
All right, we'll have you, if you'll help her get to probation, and they'll sit with her until Field of Hope gets here, and until the paperwork's ready, and they'll come bring you out the paperwork and stuff from the clerk reports. All right, then,
Something? You need something?
the entry.
I did have a quick question about it, and,
Oh, we're done, so come on up.
just needed to know, the program component, $50 page, was that be cash or?
It can be a credit card cash. I think I think they take credit cards, right?
Yeah, I think
Yeah.
they do. There may be a fee with it, but you can ask the clerk's office. It's.
Yeah, it doesn't have to get, and everything's always paid to the clerk. Nothing comes to the clerk.
Yeah, I just wanted to make sure she didn't, if it didn't have to be paid in cash, that she wouldn't have to stop.
Yes, that's a good point. And it's $250 per month, and this is just the first month payment up front. So just know that that'll be recurring as the case progresses. And I think I did sign the entries just now, so they'll be getting things ready for him to sign off.
Thank you.
Thank you. All right, and have you and Denise worked out the next hearing? Or no? Oh, you guys haven't talked about it at all, even
I talked to her, I just don't know what.
whether we're gonna, okay, I was gonna say, I figured she had time to at least know what the state's recommending.
Can you sign the piece right and please?
Oh, I thought
And dog Charlie is downstairs today.
oh, how did come on up?
He
He's friends
did,
with
but
one.
you weren't out there.
Oh.
So it's
Like Huey's on Charlie.
Yeah.
Oh, they,
then I sniffed him and then.
yeah, because they know each other.
Yeah.
There's no entry. I've signed everything that's been submitted.
You should have one right.
On right?
I thought that's what she said. She said that he
Who
was
is-
to jail, so Brandy. She said he's
Yeah.
going to jail.
Right's gonna, isn't he the one that's gonna go to Star or no? Or she-
Yeah, Drew Manning and.
The sheriff, yeah.
I.
I don't think him go down.
So, yeah, you didn't do that this morning or when we had him hours ago. So, okay. So I don't have anything right now. So if you
Okay.
can do that, that would be great.
You
Yes,
got
Scott.
one question.
Yeah.
We understand Field of Hope's on the way from truck.
Uh-huh.
She'd like to have a cigarette out front before she leaves.
Probation would have to see if they have time. I'm not gonna be, I'm not gonna do that. And what probation can, I mean. If they can, that's fine. If they can't, then you gotta just suck it up, buttercup. Like I say, be thankful that it's not jail. All right. And then if someone can go and see if, State versus Holly is ready to go.
State versus.
Holly. HAW.
You know.
It's interesting that the defendant, I assume, must have known, anticipated what the bond would be and was prepared, assuming mom can get to the home and back.
Right.
Yeah,
But probably the others.
yeah, they were aware of what that was, so it was gonna be similar. Anticipated to be similar. And those are ready, so at least you can have everything signed. It will just be a matter of setting up the repath thing. That's good.
So, right, and so formal technically, they will
Yeah,
follow.
yeah, more, these are remanded to custody, a more formal entry will follow, like we do. Denise, go. Okay. Thanks.
You see, there are a lot of simple shit there. I'm like, that's the one I remember.
Yeah. Certainly didn't smell right. Idea what they were gonna do. Have we made it through a shift change with you coming now, or did you transport?
Probably do both.
Yeah.
I picked her up and take her back. At least I could eat good and go out.
Oh, that's true. Where are you gonna go?
I don't know yet.
Someplace that you don't have here, because it's limited. Yes, good idea. Libby, did you even say hi? She ignored you.
She's sleeping over there?
No, she does go to sleep, and when she does, you come sign off. But she's awake. She's awake. She missed her little cousin dog, I guess. Do we have an agreement on Miss Holly? Do we have an agreement on Holly?
I don't know.
Oh, you don't know yet.
I don't
Okay, Denise, okay. We need to get the witnesses lined up if we don't, and ready to testify. When you, after you give that to her, or she already filled it out, or you're filling it out now?
She has not filled it out.
While she's filling it out, maybe you can find out why Denise is not in here.
What is it?
After you give that to her to fill out, or you,
She'll get Denise.
yeah.
I heard you say something about Denise, so I just, sorry. I pieced it.
No, that's all right. Yeah, no, you're fine. You're fine. I'd better calling in.
It is, yeah.
All right, so.
Next.
So what's?
Did you, what did Brown, did that Hunter Brown fill out one? I didn't get it.
Yeah, I think it's on my desk.
Okay.
So, what company first?
Agreement. Okay, we're ready to go on.
Nate versus Holly.
We are on record in the Meigs Common Pleas Court in State versus Hawley 20 CR 130. For the record, I'm Linda Ward, the Common Pleas Court Judge. Please raise your right hand. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Lisa Montour Hall.
And did you provide an accurate address, mailing, and physical phone number and email to the bailiff?
Yes, ma'am.
And is it legible?
Yeah.
Okay, great. So with that, then your attorney is going to identify herself.
Yes, I'm Denise Bunce here on behalf of Ms. Holly.
And for the state,
Yes, Your Honor, Abigail Gopi, Meigs County Assistant Prosecuting Attorney here on behalf of this.
and there's no individual victim in this case, correct? We're here for a motion to revoke community control. Is there an agreement?
Yes, Your Honor, state's understanding that the defendant will admit the probation violation in exchange for a recommendation that she have new special conditions added to her community control, that she enter into and successfully complete the STAR program, and then thereafter enter into an inpatient treatment facility, which defense counsel will probably speak a little more on that, and then thereafter continue probation.
Okay. And do you want to add anything to that, Ms. Butts?
Well, I guess what I'm gonna just tell you, Your Honor, is that I had briefly explained to Ms. Gilkey, and I was also speaking with Ms. Lavender from the probation department about Ms. Holly. What happens is Ms. Holly is on parole out of West Virginia, and part of her parole was she was to go to some type of residential rehabilitation program. She just started at a program in West Virginia when she was picked up on this probation violation here. And so I spoke with Miss Lavender about Miss Holly going to the program that she was involved with. And Miss Lavender attempted to speak with someone there, but she just got voicemail. And so
What was that program?
Recovery Village.
Is that in Parkersburg?
It's in Kearneysville, West Virginia.
What was the name of the town?
Kearneysville, KEARNEYSVILLE.
Go ahead.
And Miss Holly had even gone to the extent of paying $1,000 to be able to get into this program because she doesn't have any insurance right now. So.
We could, if she was a resident here in Ohio, and I didn't look to see what her address is, you know, typically many of the inpatient facilities will work with you to get you on Ohio Medicaid while you're an inpatient, if you're a resident here in Ohio.
With all due respect for him, I had to get out of Meigs County.
I understand that, but I mean, if you were in Scioto County or
Okay.
whatever in Ohio, and an Ohio resident is your current residence for your driver's license and your voter registration, that sort of thing. Just don't use not having insurance as an obstacle, because a lot of these places that we use that are not here in Meigs County, that are further away, will help you get eligible for Medicaid. So I just wanted to throw that in.
Yes, and I would agree. I asked her about that, but like I say, she had already paid this money, and so I guess that's part of her. Well, and she's on parole, and that's what they want her to
Yeah,
do.
sure.
She's just trying to get the quickest thing, I'm sure, that she could get under the circumstances, knowing what she knew
Right.
at the time.
Makes sense.
So she just, I had spoken to Miss Lavender about the possibility of, like, if, since our agreement is that Miss Holly would go to STAR, is that she could maybe go after she's done with STAR, she could go to this Recovery Village. And maybe, you know, and they would maybe have a bed date for her, because I know Miss Lavender shared with me that once you're getting close to your end date with Star, that they try to look for places to help you get further help and that kind of thing. So they could reach out and try and get her started on a bed date for Recovery Village. So Miss Lavender also, I'm quoting her a lot, but anyway, she said that she wouldn't be adverse to Miss Holly going to the Recovery Village from what she knows so far. I gave her probably 6 or 7 pages of stuff that they sent me
Okay.
for Miss Holly to share with her probation department, that kind of thing. So obviously that you as the court have the final say, but I just wanted to let you
As
know.
long as it's a legit place that'll give us information that has a history where you're not just in bed in patient for 30 days and out.
Right,
A lot of
it's a
those,
6 to 9 month program is what the paperwork.
most all the
we sent
successful
us.
ones are gonna be at least that long,
Yeah.
sometimes longer.
Right.
It takes a
right.
while to get the brain
That's
reorganized.
true. That's very true. So, but Miss Holly, I think, has committed to doing the hard work that it needs, that she needs to do. And so
Good.
I'm probably putting the cart before the horse once.
That's all right.
A little bit here, but
That's all right. We'll have you
some
go
of my
ahead and,
clients before, but anyway, I can handle it.
so if you want to inquire. so we
Yes,
can-
ma'am, I will. So Miss Holly, you are on probation in Meigs County, right?
Yes, ma'am.
All right, and as part of your probation, you were, let me see here, I think you were supposed to report, is that right? Is that what happened and you did not report, did not? All right, and I have, I think, the exact date, but I'm trying to.
Yeah, they're on here that there were several, there was multiple dates and multiple excuses, some of which were verified to be.
Yeah.
Yeah.
All right.
Yeah, fabricated.
And so essentially, your probation officer alleged that in September of 2024, that you had reported that you were sick, and then from there, it was another excuse having to do with bronchitis and going to the doctor and flat tires and just a lot of different things in the months of September and October of 2024. That this, well, at the time it was Miss Bullington, who's the probation officer at the time, alleged that you had essentially given her false information and did not report to probation the way you should have. Does that sound? That's right, Rose? All right. And you recognize that you're not supposed to give them false information. And you recognize that you're supposed to come and see them. You're supposed to. All right, and so you admit that that is a violation of the probation. That you did not do that, did not do those things the way you should have? Correct. Okay, all right.
The condition of probation would be that you have to be completely honest and candid. I'm
Right.
sure, and so this would be a violation of that condition. Do you admit that among the things you were deceptive about was you took an internet picture of a white car with a flat tire?
Yes, ma'am.
Because was that because you were using?
I was absolutely at my lowest point.
Okay,
And you ended up being sent to prison, I think, around that time.
I got arrested on December 9th and I got sentenced to prison December 14th.
That was in West Virginia.
Yes, ma'am.
What county was that?
Mason County,
Mason County.
for what offense?
grand larceny.
Okay. Is that
Not
related
the-
to the related to your addiction issues?
Yes, ma'am.
And did you report that to your probation department that you had been arrested and convicted in another place?
No, I didn't.
There you go, there's another violation.
Well, she just, yeah, she just.
It just
got out.
piled up. I remember she just got out when I arraigned her. Yeah.
Uh-huh. Yeah,
So these are not technical, these are very serious
No.
violations.
but, and that's why they're recommending
Sorry.
STAR program, I understand. Miss Holly does acknowledge, I think, too much, that we had some longstanding issues with substance abuse, and if you want to get help and get better.
That would be great. Great. Okay, we'll find that you violated the terms and conditions of community control, and the court's prepared to move on to adjudication and the consequence stage. Is the state
Yes.
and defense counsel?
Yes.
Okay, any reason why we shouldn't, Ms. Holly, move on to the punishment stage?
No, ma'am.
Okay, with that, the state's position again is?
Yes, Your Honor, the state would ask that the court add additional special conditions to her community control, that she enter into and successfully complete the STAR program, and immediately thereafter enter into and successfully complete an inpatient treatment program, and then thereafter continue on community control.
Okay, all right, there's no victim in this case, right? So, victim or no victim impact.
That's what
So,
the protection
so
charge,
defense
Your
counsel will move on.
Yes, Your Honor. I also would ask the court to accept, the agreement of the parties and allow Ms. Holly to go to the STAR program. And as I mentioned earlier, I would like to see her be able to go, if possible, to the recovery village. I think she's strongly desirous of being able to do that. And she looks forward to having, their help, because I think she's, from when she was there, just a very short time, she's seen and heard a lot of very positive things, and they made her feel welcome, and they made her feel part of the village.
Good.
And it made her feel like she had people that would be there to support her and help her get through her recovery stages. And she wants that, and I think that's something that's been missing from her treatment and recovery in the past. And she's wanting to change and wanting to have a better way of life, and so I would ask the court to allow that.
Ms. Holly, do you have anything to say on your own behalf or to present any information and mitigation of punishment?
No, Your Honor, I would just like to say though that I am well aware that every wrong decision comes with a wrong, a bad consequence. And me getting sentenced to prison was a blessing. So, what I did was wrong. I know that. That's it.
Thank you. The court has to and has re-examined the purposes and principles of felony sentencing, and with that examination finds that a prison term is still not consistent with the purposes and principles of felony sentencing. Instead, we want to continue offering more rehabilitative type services. So you're going to have a new condition of community control and remain on community control, but the new condition is going to be that you have to enter into and successfully complete the STAR community-based correction facility program, and that duration is dependent upon you and what programs you get involved in. So it's not a specific number of days, but it is a locked facility, and you'll go directly from jail, being a Meigs County inmate, wherever you are housed, to being picked up by STAR and taking that program, and that you have to finish that program successfully and then enter into an inpatient program and follow all their recommendations upon your completion of STAR, whatever program you go to. And I'm fine with the one you'd already paid for, assuming they'll hold your spot or give you a spot when you get out. Sign the release form, so probation gets the weekly reports on your progress, that you're still there and that you're abiding by the terms and conditions of that program and so on. And we'll continue on community control. You have to keep in touch with the probation department, because 48 hours after you are released from any inpatient or incarceration program. So if you left STAR, came home before you went to rehab, you must report in person for 48 hours, or hopefully the other way is you complete STAR, go directly to the village. And then when you complete that within 48 hours, come in person here to the courthouse. No excuses, no fake flat tires or anything. Come in person and meet with probation to get back on the schedule, because you will continue then to be on community control. You understand that?
Yes. Well, I do have a question. Is that okay?
Yes, sure.
Okay, so I would complete STAR, and there's no obligation to me going to recovery village, but I would have to report to probation within 48 hours. Is that correct?
At 48 hours of when you get out of whatever you're done.
As long as when you're not in a residential program of any sort, because essentially you're staying at STAR and you're gonna stay at that other place. When you're not staying anywhere and have your own home, they're called probation.
You got to come in person,
Come in, I'm
face
sorry,
to face
come
in person.
sorry.
And assuming you go directly from STAR to the inpatient, you don't have to come after STAR.
That was my question.
So, but if for some reason there's a gap there, then you would have to come in. But the goal would be that you'd go directly from probation to the village. And then it'll be after you're done with the village program that you would come in person. Good question. Okay. And also you have to understand that because you didn't go to prison, and I'm sure grateful for that, if you're going to continue being on probation, and if you would have another motion to revoke your probation and end up sent to prison, you have to be advised again that you could be subject to up to 2 years of post-release control under revised code section 2967.28. if or when the period of post-release control is imposed following your release from prison, and if you violate conditions of supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If, while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional consecutive or stacked penalty. And again, that's only applicable if you violate again and go to prison. That's not, you're not gonna get PRC from STAR. You also have to pay the court costs in this case. You'll get credit for time served, and you have the right to appeal this court's decision, and the appeal must be made within 30 days after your sentence, which is what we just did. If you cannot afford an attorney or the cost of an appeal, the court can appoint an attorney to assist you and have the cost of your appeal, including the preparation of transcript, paid for from public funds. Do you have any questions or anything else, Ms. Spence? Ms. Gilkey?
No, Your Honor.
All right, then we'll remand you to custody. I don't know if they have a bed date. I know we had another female, didn't we? That's-
a week from today.
Okay, so I would
So
guess
hopefully
that's
they-
probably when they would pick you up at the same time.
They said tomorrow, Judge.
Oh,
but
okay, tomorrow. Even
I
better.
also told probation though to call Star and make sure that they're not coming first thing in the morning, cause I still have to get 2 sentencing entries
Yeah.
done, and the clerks have to do their part, and Brady's already called over saying that they won't take them if the entries aren't done.
Yeah, right.
So, I mean, it takes time
So.
to get all
And maybe
that.
tomorrow or maybe a week from tomorrow. We'll see. We're getting things out as fast as we can.
Do they go to county?
Yeah, they go to Gallia and to, they'll go to either.
Yeah, I
either
think
jail.
Valley is actually a little closer.
Oh, yeah, it would be. Yeah, it definitely would be.
Probably an hour sort of.
Yeah.
1 hour.
All right. In other words, we now leave Andrea alone so she can work on entries.
Hopefully I'll.
Hear that, Jim? Did you hear that one, Jim? Hi, Jim.
Yeah.
The rule is leave Andrea alone so she can get done with these entries.
I'm sorry.
Well, not just me, I don't know what all the.
I got that turned off.
Oh, you do have it all. I said the rule is you gotta leave Andrea alone so she can work on entries. You had turned your other box
Andrea.
off.
Yeah, I turned it off walking through because if the deputies try to talk to me, all I hear is you.
Mike, okay, that makes sense.
So
Yeah.
as I pass, I turn it on and off.
That's funny.
So no harassing Andrea, so
She can get these entries done,
Amanda,
quietly if you do.
quietly. Maybe I'll just give everybody an unexpected break this afternoon that's just a half hour, right?
Yeah, you can have it.
I can do
See
it.
you tomorrow. All right, and I'm gonna start closing down some things here, including, the Zoom.
I'll shoot you now with the dart. 4 o'clock.
Get workers' comp.
Oh, no, workers' comp.